Please, your lordship. Lordship, I beg to mention two fresh matters your lordship for listing on Friday. They had
Fresh
come up
matter.
once.
Fresh
They,
matter.
lordship, they had come up once for motion, but that day we could not submit your lordship. So it came up before Bihu. Thereafter, it has not been listed. Your
Motion.
yes, your on Friday. Much obliged.
Right, Peter Lord. With the consent of the other side, I beg to mention item 13. Lordship, counsel PN Goswami is in some difficulty. Matter may be adjourned for
I'm a petitioner.
3 weeks.
3 weeks.
Mr. Anand
PK Board.
of PK Board. Learned Counsel Court of Petition. Mr. I Board. Learned Technical. Your for respond number?
Forest Department.
Submitted. Yes, the report. The protocol has the report. The prayer by the prayer is allowed. The case of
Just interim order may continue your interim order.
interim or
Publish your lordship.
May I please, Your Lordship, I beg to mention item number 11 of today's list. With the consent of the other side, the matter may be adjourned for 2 weeks, Your Lordship.
why?
Your Lordship, Mr. G.N. Sahiwala, the senior learned counsel, will appear in this matter, so he has some difficulty today, Your Lordship.
Mr. On the prayer of Mr. M. Normal Learning Court of Petition is the case after 2 weeks. On it is better. So it is submitted that complaint taken from the Learning Court. You have informed the other side.
Yes, Your Lordship, we have taken consent yesterday.
But I prefer listing of a petition matter for admission.
I think
Regarding matter
next week. Next week.
Yes.
What is the subject matter?
Regarding deep of my house.
Huh?
Deep
Deep read.
May please, Your Lordship, I pray for listing of two pending writ petition for withdrawal. Any day, Lordship.
May please, Your Lordship. WPC number 8426 of 2022. May it please be listed
What
on
is the
Friday.
subject matter?
It's an urgent matter of land eviction and acquisition.
Next week.
Next week.
Madam, matter for listing, my lord. Notice was issued, my lord, on 23/2, my lord.
What is the subject matter?
Subject matter, my lord, my land was, the land was, my lord, taken away by the state government, by the central government due to fencing, my lord. So I prayed for land, my lord. Accordingly, that notice was issued by your lord.
File.
May I please, Your Lordship. But sir, I want to withdraw this petition.
Mr. F.A. Hassan, Learned Counsel Court of Petition, has submitted command instruction on the petition urge one to withdraw the writ. I am asked anybody can to submit an opinion on it for response number 1 is present. We have to have submission made by Learned Counsel Court of Petition. That is it.
Publish, Lord.
Oh my.
May I please, Your Lordship. You know, 1 and 2 are identical in nature. You're challenging the
deduction of forest royalty from our contractor bill, my lord. Primary ground of challenge is that
What are the contracts first?
yes, my lord. But you will find at page 21, my lord, the work order. Page 21.
21.
Yes.
Original at page 24.
Lordship,
Original at page 24.
yes. In the order by the executive engineer North Lakhimpur Water Resource Division, my lord, subject flood management of river Ranganadi along with training work on both banks embankment in the Lakhimpur district. Now, my lord, you have as you have signed the
Yes, sir.
formal tender after dispositing as the money through your tender of the for the above noted work has been finally selected for acceptance as the rate as noted in Annex 1. Please start the work in consultation with the Assistant Executive Engineer North Lakhimpur Water Resource Subdivision, Lakhimpur, and then show proposed progress against the stipulated time for completion of work in the above mentioned work within 7 days time from the date of issue of the formal worker without fail. Please note that the time of completion of the above mentioned work will be 45 days only from the date of issue of the formal work order. Item work for schedule and item rate at Annex 1. Value of work 2,92,55,425. Now, lots will find that it is a work regarding flood management and time has been framed only for 45 days. Now, that the contract agreement was signed and the condition of contract that was appended to the petition at page 29, the original starts from page 51.
Come to page 25.
My lord. My lord. This is type 50 also. The deal, my lord. Mary. I'm reading in page 23, this type 2. Name of the scheme, flood management of river Ranganadi along with river training work for on both embankment in Lakhimpur district. Package number so location so. Item number 1, artwork in embankment by truck carries into locally available ordinary soil, excluding rocky soil free from roots and vegetation and filling in uniform layer not exceeding 22 cm thick, including cutting and cleaning light tangles and trees up to 50 cm plowing or roughening or benching the sheets, removing all rubbish, breaking cloth up to 2.5 cm cube, dressing as per design section, including payment of compensation for borrowing art from private land or forest royalty, if any.
Now, what
etc.
is the implication?
My lord,
Including payment of
if
compensation
I
for
borrow land
borrowing
from the private parcel,
art from private land.
then I have to pay compensation to them.
And this or forest royalty, if any.
If it is from the forest land, my lord, then I'll have to pay the forest royalty.
It is the work.
Yes, ma'am. Now the condition of contract at page 51 is the original one. The primary challenge is that there is no clause regarding deduction of forest land in a condition of contract. Now, Lordship will find page 59 first, my lord. It's Annex 4. This is the certificate issued by the executive engineer, North Lakhimpur Water Resource Division, up to date progress of all work allotted to the bidder during the financial year 2020. Now it is in respect of Pranjal Gautam Pal, the petitioner, at column 4, 5, up to date progress is 100%. So he has completed the work. satisfactorily.
Yeah.
Now, my lord, you will find paragraph 8 of my declaration. That it is stated that the first bill of the petitioner was released in the year 2015, amounting rupees 80 lakh 75,000 only. At that time, the first royalty was not deducted, my lord. Thereafter, as a part payment, the second bill by member number 22, a bill of for rupees 1 crore 5 lakh 15,175 was processed and passed by deducting the relevant taxes, including income tax, SCG, SGST, CGST, etc. It is stated that the state part payment made by the department an amount of rupees 15 lakh 7,755 was also deducted for first royalty, and an amount of rupees 37, it is income tax, my lord. Now, my lord, at this stage, we came, my lord. After such payment, a sum of rupees 1 crore 6 lakh 65,250 is now due by the department on account of the execution of debt. At that point of time, we came before the honorable court, my lord. Lordship will see annexure 5 at page 60, my lord. Type copy, my lord. Original one is at page 63, your lordship will see, my lord. There is a deal deduct that is a bill process for 1 crore 5 lakh 15,175, and down below, my lord, forest royalty, it was deducted 15 lakh 7,770. At that time, at that point of time, we came before this honorable court, and the honorable court has passed an order saying further deduction. Now, my ground of challenge is the primary ground of challenge is
Let us see the other read.
my lord,
Let us see the other read.
my lord.
And what happened after this interim order? About your final bill?
Yes, my lord.
About your final bill?
That in my instruction that is pending is not paid, but he said on the other day, my lord, it has been paid by directing the person.
Forest royalty.
In the secondary petition, my lord,
What is the contract?
same contract, the
Let
river
us
is
see.
saying.
Let us see.
Yes. Page 38, my lord. Page 30 is the final work order, my lord.
Page
38, the type copy, my lord. This to Nobin Gupta, the petitioner, issued by the executive engineer, North Lakhimpur Water Resource Division. Subject flood management of river Dikrong along with training work on both bank embankment in Lakhimpur district, my lord. Almost same, my lord. The 45 days stipulation was there, and the work value was 6 crore 40 lakhs 7,610. In paragraph of 8 of this petition also, where I have stated what is the amount deducted so far, my lord.
paragraph.
Paragraph 8, my lord. Sorry, 7, my lord. Mary. It starts from page 9, my lord.
Where is your completion certificate? Completion certificate
Yes, my lord.
available? Like the other one?
Yes, my lord. I'm no, Panjal Road. Next. Nobin. My lord, your lordship will see Annexure 6, my lord.
Page
Page, it is 84, my lord.
80.
84, my lord.
It is running.
No, it is completed, my lord. Right side, my lord, below Annexure 6, my lord, work in progress, completed.
Page.
Page 84, my lord. It is the original copy, my lord.
Hmm.
Annexure 6, my lord. Before above the table, my lord, right side.
Physical.
It is written by hand, my lord. In any case, my lord, the final bill has been passed, my lord.
Is paragraph 7.
Paragraph 7, my lord. Lordship. That it is stated that the work, aforesaid construction work has been successfully completed by the petitioner to the satisfaction of all concerned. The first bill of the petitioner was released in the month of March 2015, amounting to rupees 2 crore 22,71,525. Thereafter, as a part payment of the second bill, a bill for rupees 2 crore 11,86,511 was processed and passed by deducting the relevant taxes, including income tax, SGST, CGST, etc. It is stated that in the said part payment made by the department, an amount of rupees 29,40,250 was also deducted as first royalty. At that stage, we came before reasonable court. After such payment, a sum of rupees down below 2 crore 5,49,574 is now due by the department on account of the execution of the state road. Almost identical as in the first case.
According to you, why it is not stable?
My lord. First of all, my lord, that source that was not defined by the department, I have categorically stated in the item number 1, my lord, annex paragraph 6. That upon such allotment, petitioner started execution of said contract work by procuring material from open market, since the department did not specify the source from where the material to be collected. Your lordship has seen the schedule where it has been stated that either you pay compensation to particular land owner or first royalty. So I have paid the compensation, that is not disputed. Secondly, it has been settled by the division of the honorable court, division bench of the honorable court in Muslim Ali Miller. Unless it is specifically mentioned in the contract agreement, the department, executing department, has no liberty to deduct the first. That is the primary ground. And the water resource department, it is not the competent authority to deduct the first royalty unless there is a demand from the forest.
Muslim one.
My lord,
Because there are many restrictions thereafter. What is the primary ground?
primary ground of challenge I have taken.
Now here in Muslim Ali, it is Assam Minor Minerals Concession Rule 1990.
My lord,
That has been repealed and replaced by 2013.
2013.
So reference is made of Rule 16A there, right?
My lord,
And this contract agreement is of 2014.
my lord.
So it is in that context you have to
It is
take.
2013 rules, man.
Now what is the ratio laid down, principle laid down?
My lord, in the last decision of this honorable court, in the coordinates bench,
No, first let us see Muslim Ali.
yes, my lord. My lord.
I don't know Muslim Ali.
Yes, my lord.
It is there.
Yes. Paragraph 9 of that Muslim Ali judgment, my lord. Feeling aggrieved, the department is in appeal. Heard Mr. I. Chaudhary, Learned Standing Counsel, PWD for appellant, as well as Mr. T. Das, Learned Standing Counsel, assisted by Mr. P. Sharma,
Keep
Learned Counsel. Listener. Well, my lord, we can skip, my lord. Kindly come to paragraph 70. Learned single judge on due consideration held as under, my lord.
First let us see the provisions. What are the provisions that were considered?
In the Muslim Ali judgment. Okay. Paragraph, I'll start from paragraph 11. Minute. Under such clause 7.2 of the tender document, the contractor was not required to obtain any consent from the employer for purchase of materials which would be in accordance with standard specified in the contract. Clause 41.1 of the tender documents provides that the rate quoted by the contractor shall be deemed to be inclusive of sales and other levies, duties, royalties, sales, toll, taxes, etc. That the contractor will have to pay for the purpose of the contract, and that the employer will perform such duties in regard to the deduction of such taxes as per applicable law. As per clause 39 of the tender document, payments shall be adjusted on account of deduction of advance payments, security deposit, other recoveries in terms of the contract and taxes, and at source as applicable under the law. From cumulative reading of the aforesaid clauses, it would be evident that there is a contractual presumption in favor of the contractor that the rate quoted by him shall be deemed to be inclusive amongst other royalties. Duty is also cast on the department to deduct taxes at source, which are to be required to be done as per applicable law. Under section 3E of the Mines and Minerals Regulation and Development in 1957, minor minerals have been defined to be building stones, gravel, ordinary clay, ordinary sand, other than sand used for prescribed purpose, and any other material which the central government may by notification in the official gazette declare to be minor mineral. Thus, from the reading of the above definition, it is clear that stone, gravel, and ordinary sand are minor minerals. Section 4 of Mines Act provides that no person shall be undertake any mining or undertake any prospecting or mining operation without a mining lease granted by under the Mines Act and the rules made thereunder. Section 9 deals with the royalties in respect of mining lease. As per Section 9, holder of a mining lease is required to be paid royalty in respect of any mineral removed or consumed by him or by any person acting on authority on his behalf from the leased area at the specified rate. Assam Minor Mineral Concession Rule 1994 have been made under the Mines Act. As per Rule 16A of the Mining Rules, the lessee shall pay royalty in the minor minerals removed or consumed by him or by any person acting on the authority of his behalf from the leased area at the specified rate. From conjoint reading of the aforesaid provisions, it is quite clear that it is the duty of the lessee to pay royalty for the use of forest produce. Failure to pay royalty would invite consequences as follows. It is in the present case, it is not the lessee. No minor contract has been assigned. Though the office memorandum of the Finance Department dated 17/6/2020 to 2000 provides that the bill of contractor engaged in construction work of government department and government undertaking using forest produce will not be paid unless the forest department clarifies that the forest produce so utilized has been collected from legal source and necessary royalty has been paid. The same is not a condition incorporated in the contract agreement and therefore would have no binding force on the contractor. The learned single judge on due consideration held as under having regard to the above contention made by the departmental council, I find that it was not specified as one of the contract conditions that it was incumbent on the contractor to apply to executing agency, that is PWD, for issuance of forest permit from the nearest forest division or procuring the materials used in the contract. It was also not specified in this as materials are to be procured from particular government source or a particular government lessee. It is also not incorporated in the part of the tender condition that the petitioner is unable to produce a certificate showing use of forest produce on such royalty has been collected. Is billed to the extent of royalty payment to be deducted at source. Under these circumstances, it is difficult for the court to accept that the action taken by the authority is in accordance with law. If such obligation would have been incorporated in as one of the contract conditions that the contractor has to secure his supply from particular government query, and then if he would have acted contrary to such requirement, the department may have justified in deducting amount on account of royalty from the running bills of the contractor. But in the absence of such clauses in the contract, the action seems to be unauthorized. It must also be borne in mind that even in cases where supplies are secured from a forest approved lessee, there can be no guarantee that the material used by the contractor were royalty paid material, as even a approved forest contractor may supply materials on which royalty has not been paid. Therefore, in my opinion, in my view, it was firstly necessary for the department to incorporate appropriate condition in the contract to bind the contractor that he has to procure his forest material requirement from specific sources, and on his failure to procure material from such sources, there could have been an adverse presumption drawn against the contractor. Secondly, the condition incorporated in the memorandum issued by the Finance Department on 76/2000 should also be specifically incorporated as one of the contract conditions, as a contract in the question was awarded in the year 2005, that is 5 years after circular of the Finance Department. Not having incorporated the requirement insisted upon by the Finance Department as a condition contract would disincentivize the PWD from realizing royalty from on forest produce, which really is a burden either the Forest Department or Mines and Minerals Department. The action against the contractor is initiated by a department on the basis of presumption and surmises, as there is no absolute certainty that no royalty is paid on the material used by the contractor. No opportunity was afforded to the contractor before such adverse assumption was made by the department to order the deduction of amounts from the running bills of the contractor. If royalty had actually been paid on the material used by
Okay.
the contractor,
Okay.
deduction
Okay, Mr.
further amount.
Okay.
Yes, ma'am.
Now, what is the ground they had taken in this
Yes, ma'am.
high or they are giving?
My lord. Basically, they have taken 3 grounds, my lord.
Let us
One,
see from
they
there.
have heavily relied upon this notification of 17.6.
First, their pleaded ground.
Yes, madam.
Okay, some time will be there. Some time.
The affidavit in opposition filed by respondent of 4, madam. Basically, they have pleaded that the mining plan was not prepared, my lord, and there is no first ground, and there is the second ground they have taken, my lord. the affidavit, they have taken primarily that ground of mining plan. In the objection in the vacating application, they have taken another ground, my lord, that there is no permission from the Gaon Panchayat. My lord. Basically, these two grounds, and they are relying upon the notification of 76/2000. These three grounds. In the ground. As regards the
Now, Muslim Ali says,
Yes.
let us come back to Muslim Ali.
my lord,
At that point of time, it was 1994.
my lord.
Paragraph 18.
18. We are in agreement with the views expressed by the learned single judge. No appropriation of money from the contractual bill dues is permissible unless backed by statutory provision or express provision contained in the contract agreement binding on to the parties to the contract.
Now, first part. No appropriation of money from the contractual dues is permissible
Mal-
unless backed by statutory provision.
Yes, ma'am.
And second part is by express provision contained in the contract agreement binding the parties to the contract. Your argument is that there is no express provision in the contract.
Mal-
So binding the parties to the contract to pay for it.
Lord.
What about this other part? No appropriation of money from the contractual dues is permissible unless backed by statutory provision. Now, here your case is that you have entered into agreement with private landowner
Lord.
and you have extracted the ordinary art
Mal-
from private land.
Okay.
Now, what about this provision? No appropriation of money from the contractual dues is permissible unless backed by statutory provision. It is
Well,
to be submitted in the context of Assam Minor Mineral Constitution Rules 2013.
Lordship will see rule 4 of the rule 13, rules of 13.
Is there?
Yes. Four and 5.
Rule
Rule 4, my lord.
4.
Relaxation in certain cases.
Any definition of minor mineral?
Yes.
Where is that?
Minor mineral is not defined in the rule 13.
Minor listed, it's schedule. Schedule X and Y.
Action.
Let us
Yeah.
schedule X and
Schedule Y. In my book is 855 pages.
schedule Y.
Y schedule X and Y. Y is page 856. Minor minerals for uses other than in industry. Gravel, when used in construction of roads, buildings, other than mines in the large scale for export and for construction of dams, dikes, bridges, etc. Ordinary clay, other than used in cement
It
manufacturing.
is after 15. Ordinary art,
Yes, madam.
15.
Ordinary art.
Ordinary art. It's rule 4.
Rule
Okay.
4 I am to rely upon that. No royalty or permit fees shall be charged or transit permit is required for. I rely upon clause 3(4), my lord, of 2, my lord. I'm sorry, my lord. 4(2). No royalty shall be charged for removal of any ordinary art by a person from his own land for meeting personal landfill requirement, either in another agricultural field or for meeting his personal
Rule
bona fide
4,
requirement.
rule 4(1).
One, it is
Hmm.
regarding the royalty, relaxation of royalty, my lord. I'm relying upon 4(2), my lord.
No.
Sub-rule 2. No royalty shall be charged for removal of any ordinary art by a person from his own land for meeting personal landfill requirement, either
For
in
meeting personal
another
land-
agricultural field or for meeting his personal bona fide requirement.
It is per-
Now that
So it is personal.
no, my lord, now that the person he has giving his land for his personal benefit, my lord, some on some consideration. His
No
Even
royalty shall be charged for removal of any ordinary by a person
two parts, my
from
lord.
his own land.
Own land for two.
One condition
Yes.
is from his own land. Second is for meeting personal landfill requirement. That
His
is
agriculture,
his own
his land, my lord.
in another agriculture.
His
It
field,
is his agricultural
or
for meeting his personal bona fide
Yes.
requirement.
Yes.
So it is entirely it is personal.
yes, my lord. So because some with some consideration he is giving his land, my lord. Bona fide requirement. Now we'll come to rule 48 regarding preparation of mining plan. They are taking this down. Last we got it. Rule 48.
Yes.
Rule 48, my lord. Mining operation to be undertaken as per mining plan. It is part 3, chapter 9. Any mining operation under a mineral concession granted under lease, these rules shall be undertaken by a mining concession holder in accordance with a duly approved mining plan. Now your lordship will take note that here it is not a mining concession. I'll come to definition.
No,
of
your role is to collect. Your role is not to carry out any mining
Yes, my lord.
operation
They are relying
to
that the-
extract ordinary art.
Yes.
Otherwise, if any mining operation is carried out to extract any minor mineral,
by
then it is to be permitted.
yes, my lord.
But
My
here
lord, they are
your
taking
role
this
is
down. They are taking this
your-
down. Therefore,
You are not concession holder,
no, my lord.
right? You have to collect ordinary art from one source
Yes, my lord.
and utilize it to carry out and execute the contract.
Yes, my lord. My
Right?
lord, they are taking it down. Therefore, I am indicating. And there is a proviso also, my lord. Provided that the state government may exempt certain specific nature of mining activities from requirement of preparation of a mining plan. Even, my lord, that Lordship has seen that nature of work, the flood management, then only the 45 days was allotted, my lord. There is
But
exemption, my
exemption
lord.
was not there.
Yes, my lord. And mining concession is defined rule 2, my lord. Uh, Q, my lord. Mining concession means a mining lease. It is not a lease in the present case. For a mining contract or permit in respect of mining minor minerals and includes quarrying permits and any other mineral concession permitting the mining or minor mineral in accordance with the provisions of this rule. Therefore, in my respectful submission, this clause of rule of 48 doesn't necessary in the present case. I am not a concession holder. I am not operating any mining contract area. At third round, they have taken the rule 27 of these rules. A
What is the
requirement
first ground taken? What is the first ground? What is the first ground?
preparation of mining plan.
Second ground?
Second ground, they have taken the
Rule 48.
27. Rule 27.
Second ground?
Yes, my lord.
No, because you said third ground. You said third ground.
Now, basically, two grounds, mining plan,
Okay, come to 27.
based, rule 27. Permits for extraction of ordinary clay and earth. Save in the cases covered under sub-rule 2 of Rule 26, the competent authority may grant permit for lifting ordinary earth from an area not already granted to any mineral concession to the landowner or the person having consent of the landowner or on submission of an application. The permit for extraction of ordinary earth shall be granted only up to the maximum depth of 9 feet measured from natural ground level of that area. 3 is important. The permit for extraction of ordinary earth clay in respect of any land which the ownership or management vests in Gram Panchayat. They have taken this ground. Shall be granted only if a resolution is passed by the effect by the Gram Panchayat and approval of the concerned deputy commissioner is obtained by the applicant or the Gram Panchayat. Well, this is not a land owned by the Gram Panchayat. In response to their second ground. In third round, they have taken the notification of 17. (17.6) notification is
Where is
the
the first schedule?
my lord,
Where is the first schedule?
that
First schedule. We have seen
contract.
Yes.
Now, my lord, the third round, they have taken the notification of 17.6, my lord. That's a part of
76 of
2000, my lord. The finance department notification.
that
my
has been taken care of by Muslim.
lord. Yes, my lord.
Unless it is part of the
Contract agreement,
contract agreement, you
cannot be.
cannot
Yes.
enforce that.
my lord,
Cannot enforce that.
my lord,
But my question is that Rule 27,
my lord.
it has some applicability.
No.
Which has any decision discussed on Rule 27?
No, my lord, but the
Yes or no? Has any of the decision deliberated on Rule 27?
no, I have not found any decision regarding Rule 27. Now, my respective submission, my lord, Rule 27, they are relying upon if the ownership based on the government.
there is any part. That is ownership rule, sub-rule 3.
My lord. Their land,
Sub-rule 3 is with regard to the land, any land,
my lord,
in respect of which the ownership or management is in a company.
my lord,
And that has to be
by resolution,
by resolution and thereafter
with the consent of the
approval of the deputy.
My lord.
But rule 1, sub-rule 1,
Rule 26, my
rule
lord,
sub-rule 1 of rule 20. Sub-rule 3 comes later.
my lord, Rule 26.
Sub-rule 1, please read.
Yes.
Save in the cases covered by
covered
sub-rule
under
1 of ordinary so and so
Yes,
rule 26. That is big art,
My lord,
right? Big for
the
big loan,
competent authority may grant permit.
migrant farming for
Yes, my lord.
lifting
No, my lord, it
ordinary.
is in respect of permit area, my lord. There is definition of permit area also.
First read it.
Yes, my lord.
Read it totally.
May grant permit for lifting of ordinary earth from an area not already granted to an mineral concession to the landholder or a person having consent of the landholder on submission of an application.
You are the person having consent of the landowner.
My lord,
You are in the category of the person having the consent of the land.
no, my lord, first the lordship will see Rule 20, Chapter 5, it starts from Rule 23, my lord.
Okay, we'll read.
Yes,
First, let us examine this.
yes, my lord. Yes, my lord. No, in relation to Rule 27,
We'll go to it.
yes, my
Go
lord.
to it.
Yes, my lord. I'm reading again, my lord. Save in the case covered under Rule 2 of Rule 26, the competent authority may grant permit for lifting of ordinary earth from an area not already granted to any mineral concession to the landowner or the person having consent of the landowner on submission of an application. A permit for extraction of ordinary earth shall be granted only up to a maximum 20. Now
Let us model form PIM3.
PI
M3.
yes, ma'am. Getting application form. May I read, ma'am?
Hmm.
Application for grant of permit for extraction of ordinary clay and earth. Yes, sir. The applicant is the owner of the land or having the written consent of the
Owner
land.
means it is patta land,
My lord,
or is having written consent of the land, owner of the
my lord.
That is you.
Yes. And have to remove the ordinary earth for leveling the land or selling the same for commercial purpose. As a
Selling the
result-
same for commercial purpose.
Yes, madam. As a result of leveling of land or excavation, ordinary clay earth excavated is to be disposed of, for which permission is solicited. Now you look.
See the details of the area for which permission is being sought. See clause 2.
Yes, madam. Plus to the details of the area for which permission is being sought. Location of the area, purpose, total area to be excavated, level,
Now come to your agreement, contract
my lord.
for the first one. Quantity page 25. Quantity is clear. 2 parts. 1,58,475 cubic meter. Next one is 31,812 cubic.
The lordship is the
That is
reading.
the art to
Lordship
be
is
extracted.
reading from page 25.
Page 25.
My lord. Regarding that PIM
Say
form
quantity
3,
page 25.
page 25, I'm,
Quantity.
yes, ma'am.
Quantity is definite,
My lord.
right? Now, why it is not applicable? PIM
Lordship will see page
Rule
77.
27(5).
Yes, my lord, I am replying to that. Your lordship will find that application in form PM3 in the objection file in the first case of packaging application. I have applied for it.
You have applied.
Yes, my lord, this is a part of the,
Okay. Let us see.
Yes.
That is why I am asking.
Yes.
We can proceed only one. We cannot jump from one to another.
my lord,
Where is that?
page 77 in my reply. The packaging application.
Yes.
It is in form PM3, my
Right.
lord.
Yes. Good enough.
Yes.
Complied.
My-
Yes. What you have done, Mr. Das? What you have done on it? There is nothing. He has made clear environment. This is your objection or India application? This is part
This
of
is
your
objection,
objection or
this is objection to the packaging application.
objection?
Yes.
Yes. Now, what is your reply to that? It is there already, received 2016.
Yes.
Next question will come later.
My lord,
Next question will come later.
My-
You are in urgency to vacate. Now tell me about this.
This is an application which the petitioner has
You
expressed.
you try to put the burden that forest royalty is not paid.
Yes.
For ordinary art.
Okay.
For excavating it from private patala.
Okay.
And there is a set of procedure laid down in mineral concession rule. That is a statutory breaking Muslim Ali.
Okay.
Either part of the contract that finance department
not
notification is not part of the contract. Right? That cannot be a ground. That is a division bench. I am bound by that. Unless it is made part of the contract. Secondly, statutory breaking. Statutory breaking will come to the next question later on. Now, this is the procedure laid down in the statute, say mineral concession rules, that and there is a procedure laid down.
Okay.
He has to apply. Right? Now, what is your answer to this?
Accordingly, he has applied this.
Yes, he is there. It is
Yes,
recorded. Now, what is your answer to this?
Lordship, this is an application which he has addressed to the range officer of the Harmony. That is the
He is not supposed to. You are not the owner of the ordinary.
yes, I am not. We are not the owner, Lordship.
You don't have anything to say.
Lordship. But this application, the petitioner has not submitted at the time of submitting his bill, because of which his forest royalty has been deducted.
No.
in the year 2000.
Not you are not supposed to act on presumption and surmise. That is also Muslim act. He has not. He has might be, might not be. No, you cannot act. Now he has shown it. That he has acted. If they do not, there is another interesting part. But any permission granted?
The next,
Not required. Any mining plan is not.
No. This is the forwarding by the ranch officer at page 79. Next page, my lord.
Forwarding.
Yes.
Let us see.
Now, Lordship will take note that 45 days of the binding of
Where is
the contract. Only 45 days was
No, no.
granted.
Ah.
And it is a contractor regarding management of flood of the river, the Argentina.
No, you have completed it 2019. They have permitted you to continue. It is not 45. It was not restricted to 45 days ultimately. You completed it in 2019. I have seen it. Now question is, he has asked for permission. Range officer has forwarded it to the DFO. So forest department is well aware that he has applied for permission
He has
to,
applied.
to collect.
Okay.
Whether they have acted or not acted under the minor mineral rule, that is their body.
Okay.
Right?
Okay.
Now tell me, what is the requirement? And more, what is the more requirement?
Lordship,
That is there, they will take action against you.
that
You
is,
are not, as a water resource department,
Lordship,
you are not authorized to act on.
Lord.
That is their
the
bureau.
forest department. That is the
At
forest
least from the document.
Lordship.
But from the writing of the letter from the range officer to the DFO,
Lord.
it clearly indicates he sought for.
But it is not there whether permission has been granted or
That
not.
is a different thing. I have said.
Yes.
You don't have to make submission. You are not authorized to make submission for forest.
Lord.
But there are correspondence.
Lord.
That from range officer to DFO.
Lord.
Whether they have acted on it or not, that is a different thing. So issuance of permit because of non-issuance of permit, suppose for a moment, non-issuance of permit by them, but despite that, he is collecting art from the private party.
Lordship.
Okay?
Lordship.
Then what action you can take? No, you cannot take any action. Forest department.
Lordship, we have deducted the forest royalty, and the royalty has been paid to the account of the forest department.
Why?
Since petitioner has failed to provide us the
You answer for them.
Sure.
Sub rule 5.
Sure.
You have to answer. Of rule 27.
Rule.
The royalty shall be charged on lump sum basis on the quantity or volume of the art for which permit is applied as per rates prescribed in the first city. The payment of royalty in these cases shall be made in advance for the complete financial year or part thereof. Now come to the first. Come to the first. Last page. First it, you don't have this.
Lordship,
Open it. Open it. First schedule, last part. End of the.
Yes.
End of the book. Last.
First schedule, last schedule.
Name of minor in the first schedule, rates of royalty.
Yes.
Rule C, rule 27.4. Right?
Lordship.
See, first schedule,
Lordship.
rates of royalty. Then next line, see rule 86, 26.6 and 27.4. Right?
Yes.
Then first column, CL number, name of minor mineral, second column, rates of royalty.
My
Now come to 24.
ordinary rate.
Ordinary rate. What is the rate of royalty?
No, not me.
Nothing. Nothing.
Nothing. No rates of royalty. For ordinary art, 27.
Lordship.
At what rate you are collecting?
That is,
Who permitted you?
Lordship, that is the instruction.
There is no rate of royalty fixed. For ordinary art collected from one's own personal land or collected by one with the written permission of the owner.
Mal-
So far, the petitioner is concerned, he made an application as per form IMP or whatever,
PM.
and that was received. It appears from the range officer's letter written to the DFO that this is done. Now, suppose permission was not granted, he has collected it unauthorized. It is for the forest department to take action. But any view of the matter, what is the rates of royalty to be collected as per statutory provision? Nothing. Nothing.
Yes.
Finance department, it should be made part of the contract.
Lordship.
First ground, your one of the grounds. Second ground, Rule 27.
Rule.
They come after discussion. We have arrived at this point.
Lordship.
Now, what are the other grounds? Has any of the discussion or any of the authority referred by you have discussed about Rule 27? No.
No.
Any of the division bench, any of the single bench or division bench has decided, deliberated on that finance department notification,
My lord.
to my understanding.
Yes.
But whether any of the
Lordship,
has deliberated on Rule 27, just tell me.
Rule 27 notice.
I have not read entire. I have just read Muslim.
One is
There are many decisions.
Yes.
Everybody has submitted.
RTN construction, one section is there. That is
The last coordinate
2018.
bench.
RTN.
RCM.
So first, you submitted some other decision.
Yes, my lord. In the.
Some-
Yeah,
some-
delaying upon the. It is in the case of State of Assam versus Messrs. GH.
GH, GH Bijapura. Lordship.
That
That is, I'm
Has this authority deliberated on Rule 20? I am not ready.
my lord, I have found.
This has dealt with,
Rule 48.
no, this has dealt with Assam Minor Mineral Concession Rule 1990.
Another aspect in this.
What?
Yes,
So, first, one by one, whether this Bijapura decision has dealt with Assam Minor Mineral Concession Rule 2013.
2015, no,
13.
it deals with 1942.
That has been, let us see. Let us see the repealing provision. Where is the repealing provision? Sir Hazarika?
Yes, my lord.
Repeal.
Repealing 79.
79.
9. Yes. The Assam Minor Mineral Concession Rule 1994 as amended from time to time in their application to the state government is
Gone.
hereby repealed.
Gone. We cannot rely on Bijapura. It is repealed by 2013 rule. And this contract agreement are of 2014. Bijapura goes. But so far as one, the observation in Muslim art, either by statutory backing or should be part of the contract. Right? It is not part of the contract, admittedly.
It is there.
I have. And so far statutory backing is concerned, it is to be governed by 2013 rules, the ordinary art, no other rules.
No other.
So far, royalty to be collected is concerned, it is a no rate.
No.
No rate. second part, whether it is a part of the contract, specifically authorizing you to
Well-
collect forest rent
Amen.
from the contractor. Let us see once again, Muslim Ali.
My lord.
You have to read paragraph 11 also.
My lord.
Here no royalty, fixed rate. Section 11, paragraph
11.
the action against the contract.
The action against the contractor is initiated by the department on the basis of presumption and ceremonies, as there is no absolute certainty that no royalty is paid on the materials used by the contractor. No opportunity was afforded to the contractor before such adverse assumption was made by the department to order to deduction or of amount from the running bills of the contractor. If royalty had actually been paid on the materials used by the contractor, deduction of further amount as forest royalty would amount to double charging of royalty, which cannot be permissible in law. In any case, revenue recovery cannot be permitted by presuming fact without
Your
statutory
statutory support. Now, paragraph 12. It is responsible to the mining, it is not the obligation bears by the contract. The absence of specific provision incorporated the contract. Now, paragraph 13.
Paragraph 13. As a consequence of
department
this
would take-
order, department would take necessary steps to pay to the petitioner his due amount without deducting any amount as royalty payment. The deduction of rupees so and so already made will be paid to the contractor within 6 weeks from the theatre receipt of the court order. We are in
Single judge observation, paragraph 7.
yes, no.
Single judge observation, it is part of paragraph 17. This forest department OM has been dealt with in paragraph 16, right?
My lord, finance department.
The same is not a condition incorporated in the contract agreement. It
My-
goes. It is not incorporated. Now, paragraph 17. Single judge observation which has been upheld by the division.
My-
Having regard to the above contention made by the client that it was not specified as one of the contract that was the contract or apply the existing from the nearest forest department not specified that such materials are to be collected from particular government. It is also not incorporated. It is also not incorporated. As part of the tender condition that if the petitioner is unable to produce a certificate showing use of forest produce on which forest royalty has been collected, his bill to the extent of royalty payable would be deducted.
So, under these circumstances,
Unless these circumstances, it is difficult for the court to accept that action taken by the authority is in accordance with law. So, if anything, if there is any amendment to this rule fixing a rate of royalty, then you may have a escape rule. Primacy is appeal. If suppose 1% is later on, I don't know it is correct or not. Only I can give you 1 day time. Otherwise, any other ground you are urging? Apart from this, what we have deliberated, Vijapura is entirely on 1994 rules. You can go through if anything on 2013. Admittedly, 2013 rule has come into force in 2013.
Right.
This contract agreement
of 2000.
are executed in 2014. So whatever statutory backing is required, it is only governed by 2013. We cannot make any discussion on 1994, which has been repealed.
Correct.
Right?
Correct.
Now, within these four corners, Muslim Ali has made general observation, unless there is statutory backing or specific condition.
Correct.
So for finance department, OM is concerned, that still holds the field. I think there is another decision single discussed that unless it is made part of the contract, you
Well-
cannot extract forest royalty. Now only thing is statutory backing. It is Rule 27. Now Rule 27, one part they have complied. Forest department, they are sitting over the matter, it is their issue. That yes, without our permission, you have extracted, collected card, ordinary art from a landowner from which he has already taken consent. He has made it clear with affidavit. Range officer also forwarded to TFO, his higher authority. From that letter, it is clear. Even if permission was not granted, and petition has collected ordinary art,
No,
it is for forest department to take action, whatever consequence. But still land, the rate of royalty to be collected is 0.
my
Have you got my point?
Yes, sir.
Now, if in the meantime, suppose this is typing mistake or whatever, if 1% is there or 2% is there, let us see the other royalty,
my
rate of royalty. Whatever it is, per cubic meter. Per cubic meter royalty, right?
my
But as against ordinary art, there is no rate.
no right.
If no rate, no rate. No means no.
There is some.
That is why I am saying that I should not also go wrong. That is why I am giving you some breathing time to obtain instruction. Whether any rate of royalty for ordinary art
Specify.
is specific. I can give you 24 hours time or 48 hours. 48 hours. Anything more?
No.
That's all?
Right.
Hijapura will not come in.
My lord,
Muslim Ali, it
Bijapura-
is general.
Yes, my lord, Bijapura, what I found, my lord, on
Okay.
factual point, my lord. There is a specific clause in the agreement. And the person, the contractor, that there is a specified place from where to be collected, he violated.
Okay.
That 2 points.
Find out from Vijapura anything in
Look.
your support is available.
Look,
Right. Otherwise, that day I glancing through this RCN. Let us see
RCN.
RCN. What it says about this
RCN is
OM.
OM, my lord, OM is clear. Regarding the OM, my lord,
Firstly, let us see the issue.
yes, my lord,
Let us see the issue. Issue.
yes,
Para 3.
my lord. Mary,
Issue 1
whether the state authority, that is the Public Works Department, railway
or water
sector,
resources. It can be water
Can deduct-
resources. also.
can deduct forest royalty from bills, security deposit of the contractor in absence of any stipulation in the contract agreement, empowering the employer state to do so.
What is the answer?
Answer the
contract
issue,
agreement, there is
answer of the issue number 1, my lord.
contract agreement, there is
No.
Answer
the
the issue at paragraph 14, my lord.
paragraph 14.
14. That
Okay, 1 and 2. Okay,
issue
let us,
one and two
let
has
us see
been-
to, issue number 2 also.
issue, my lord. My lord, whether the decision of the division of the first issue in Muslim Ali versus Twenso is a binding precedent or the same is in conflict with the decision dated Twenso in another division bench has been Dutta Krishna Stone. Answer at page paragraph 14, my lord. This judgment in Muslim Ali makes it clear that in absence of any contract condition, recovery from contractual bills cannot be made against forest royalty.
Regarding the
Regarding OM dated 17/6/2000 issued by the Finance Department, it was specifically held that thus OM ought to be specifically incorporated as one of the contract conditions to enforce the same to or to take benefit of the same, otherwise the same is not permissible. It was concluded that as per provision of the Mines and Mineral Rules, it is the responsibility of the mining lessee to make payment to the forest royalty, and it is not the obligation of to be discharged by the contractor in absence of any specific provisions incorporated in the contract. Thus, view was affirmed by the Honorable Court Division Bench in as much as in Tinoin Associates and in all subsequent decisions of this coordinate benches, the decision of Muslim Ali has thoroughly been followed. In Durga Krishna's source, a specific clause was inserted in the contract itself with a stipulation that whenever forest produce like sands, stones, timber, etc. are used in the work, the contractor will have to furnish documentary proof that requisite royalty on the such produce has been paid to the concerned department. It was the finding of the division bench in Durga Krishna's source that the view of or mandate of the mandate of OM that is joined to of Finance Department such clauses was incorporated. There is some distinction, madam. There is a specific clause for payment of royalty in Durga Krishna, and the OM was also incorporated.
So by clause small Roman 4,
4 million.
Ah.
In fact, the Tinoin Associates specific direction was issued to the effect that henceforth a clause of the OM that is trenches shall be incorporated in contract. However, it is informed that such clauses has not been incorporated in any of the subsequent contracts.
so on OM we have to hold like this. We cannot depart unless we disagree.
And clause 6, Roman 6. That Muslim and effect of Muslim Ali. In the case of Hari Singh versus Trencher,
No, this is for a court that there should be
Mal-
judicial
uniformity
consistency.
should be there.
So unless we differ with this view,
Mal,
then we have to refer it to the larger.
mal.
But if we agree, we have to follow. So far as 17/6/2000 is concerned, this is clearly held enforcement unless so only thing is none of these decisions has discussed rule 20.
Mal.
Am I clear?
Yes.
And rule 27, rate with first city has not prescribed any
Any-
rate of royalty. So in the absence of any rate of royalty, how can you collect
Right.
royalty? And more particularly in view of such precedents, such law, like 76, without incorporation, you cannot. Am I clear?
Mal.
If 1 rupee, 50 paisa or 2 rupee, then it has a statutory back. If no royalty, no rate,
No,
nothing can be collected. State will not be authorized. That is consciously left blank. But we cannot say that it is unconscious. So you have called rate. You come up with rate, and that has to be our perspective also 2015 also will see that.
mal.
Yes, 2015 some rate of royalty is there, but that can only be prospective.
Yes.
Or 2019 can only be prospective. Then he has done his work before that. Only this. Thursday? After
His lordship, can it be on next Tuesday, Lord? Because
this court. This
lordship,
bench will
Oh.
take up the
lordship, because today I am leaving for Delhi, lordship. I have a case tomorrow at Supreme Court.
Huh?
Tomorrow I have a
Can
case.
be on the Friday, my lord, small
Or-
query on the
Or
Friday.
take a chance. Friday you were there?
Yes,
Friday? Take it now.
Only this
Subject.
query only.
Yeah. I'm just learning because that's all. Uh, Thing of Friday in order to complete
No more.
his instruction. Is like according to Friday. In time order.
Public. If
It was the registration was cancelled. Thereafter, they preferred appeal. Appeal was taken on the ground of there is a
No, one more. Can you? It may happen that this registration will not be revived.
that
Now,
can-
any instruction, any written,
Lordship, my instruction is that
you're Marvel,
yes, no,
but is there any procedure? He can go for praise.
no, press lordship it is always open to him
No. Is there anything?
because his registration is cancelled. Lordship,
So I do not want to want the petitioner to be prejudiced. And I do not want the state revenue to be prejudiced. Can you get something in writing that it is open because it is open for the petitioner to apply for press registration? 1 or 2 lines.
That-
Subject to payment of
yes,
all the dues to the earlier due.
that can be.
Something. Then he will not be prejudiced.
Yeah.
Input tax credit he will not because of his own fault.
My lord,
I am not in favor for that
but relying,
because of
Yeah.
Glaxo,
On Monday, Lord.
King Enterprise. It is
lordship, regarding this aspect, my lord, if the lordship permits me, I will only one submission before your lordship. In Mapatla Industries Union of India 1997, there is a 9 judges bench judgment of the Honorable Apex Court, my lord. I have already given this citation, my lord, where the Madras High Court, relying on this judgment, my lord, lordship, relevant para, my lord, kindly see 77. Only 4 line or 5 lines, my lord. The moot question in the Sikh enterprise,
What is a Mofatlal petition?
1997 5 SSC, my lord, paragraph number 77, lordship.
What?
What is the legislative intent of regarding a particular special legislation, my lord?
That is discussed
Yes, ma'am. Now another
in Glaxo.
yeah,
Mofatlal Industry, this court went on to observe that an act cannot bar
yes, ma'am.
and curtail limit
Yes,
under
ma'am.
Article 26
Yes.
or 30
Yes.
of the Constitution.
Yes, ma'am.
The court, however, added a word of caution
Yes, ma'am.
and expounded that the Constitutional Court certainly takes note of the legislative intent
Yes,
manifested in the provisions of the Act and would exercise jurisdiction consistent with the provisions of the amendment. To put it differently, the fact that the High Court has wide jurisdiction under Article 226 of the Constitution does not mean that it can disregard the substantive provisions of a statute
Yeah.
and pass orders which can be settled only through a mechanism prescribed by the state. Then it has also discussed ONGC case.
Yeah.
And thereafter it has discussed power under Article 142. And
Now-
in 142 also.
now, my lord, I have relied
Now let
on,
us read 4 lines of your offer.
yes, my lord. My lord is absolutely right, my lord. In this
And
matter,
it is not a case that an exception can be made.
yes, my lord. My lord is absolutely right, my lord.
Which
Another
paragraph?
Lordship, kindly see paragraph number 77, my lord,
7.
if I'm wrong, my lord.
Which part?
Another High Court was also to decide. How can another, my lord, the another High Court?
No, definitely. Mr. Abdul.
Yeah.
Maffatla has been explained by which High Court? Which High Court? This is judgment of which High Court?
My lord, this
Madras.
Madras.
And Maffatla has also been explained by Supreme.
Yes,
Now which one?
my lord is absolutely right. Supreme Court will follow.
One will take.
Yes, my lord. But another
It
judgment,
has been beautifully explained.
yes, my lord, yes. If the lordship permit me, I will rely another judgment, 2015, 7 SSC, 58, my lord.
But it is
Only
name of
my
the judgment.
lordship, para 38, my lord. If the lordship, I will satisfy.
Limitation Act will not come.
That has been,
Whether it is relevant to a specific place,
yes, my lord.
this does
My lord, the custom
29
tax,
2, because it is specific, specially
yes, my
the case subject of this act pertains to a special list
yes,
or general list.
yes, my
29 2
yes, my
will come in respect of registration where there is no specific period laid down in the special list.
yes, my
Now tell me, on what, in context of what act is judged?
lordship, kindly see,
In the context of what?
yes, my lord. In this case also, in the Customs Act 128, there is a provision of the appeal.
Where is
And
the
the
Customs
appeal
Act come?
provided within the period of 30 days. And the condemnation period also delayed, my lord, within the period of 2 months, that is the 16 days. Whether the moot questions before the Honorable Supreme Court, whether that can be condoned or not. The Honorable Apex Court clearly stated that that cannot be condoned, but the ratio laid down by the Limitation Act would be followed. Lordship, kindly read the para 38, my lord. If I may not be wrong, my lord. If I am wrong, my lord, I will,
No.
whatever may be.
We have to understand.
Yes, my lord.
Let us see the provision.
Yes. The provision provided page 87, whether the principal section 14 would be applied to an appeal file under section 120 of the Custom Act. My
What is the paragraph?
Lordship, kindly see para 38, running page 88 of the judgment. my lord.
Already read. Now, what do you want to
So,
bring in light?
so my lord, I try to just saying, my lord, that that I have filed the appeal before the GST authority, my lord, that they had laid it down the Supreme Court judgment that beyond the period they cannot be condoned. My lord, they have absolutely right, but my lord, the moot question whether they are the quasi judicial authority, they cannot condone. But when I come before your lordship under Article 226, the court
It
can.
does not say so.
That is
This judgment does not say
does
so.
not say. My lord is absolutely
It
right.
says, yes.
Yeah.
If you prosecute something bona fide
Bona fide.
in another forum, that period is required to be considered in the context of Section 14 of the limit.
Limited.
It does not say that when an appeal is preferred beyond the period of limitation, normal period of limitation, or beyond the extended period of limitation, that you have to condone. Yes, in the meantime, if prefer something, you approach another forum, and time spent, you spend the time there,
Yes, ma'am.
then 226 power
Power
will
can
be exercised in the context of Section 14 of the limitation. That is not
that is
nothing.
But my lord, my
See, Mr. Counsel, this is also not to your SQ, though it is of some,
to some extent, my lord,
but 226, it is not said.
That-
In suppose they do not consider
Yeah.
Section 14 principle,
yes, ma'am.
then 226 will come.
Yeah.
But does not say that
That is
there is another thing. Exception is made out.
made of
Suppose 3 months time
Yeah.
for filing a bill.
Filing.
You prefer repetition within that limitation
yes, my lord.
instead of filing an appeal.
Yeah, appeal. I choose another.
Then principle, then by the time your repetition is dismissed, period of limitation is over.
Over.
Then 226, you please apply principle of Section 14
Yeah.
to give some relief to the
Yeah.
petitioner for the purpose of filing it.
Filing.
That is the principle.
Yes, ma'am.
Then when your everything is beyond time, because you see paragraph Glaxo, paragraph 22. In that case, it appears that a writ petition was filed within the statutory and legal remedy was being pursued in good faith by the assessor. Mr. Cal,
I'll try to protect my
take
position.
actually something in writing so that
Yes, sir.
state is not prejudiced as well as the petitioner is not.
Yeah.
Yes, because it is his fault. Not preferring it is your decision
My lord,
within time.
that is
And you have to suffer for something. Court cannot come to your rescue.
On Monday, Lordship, I'll open that.
Monday, no.
Then
Whatever you have to do, you have to do it within this week.
on Friday.
Friday.
Not on Thursday.
Thursday. Deeply obliged.
Just something in writing.
I'll-
Or if anything is there,
Yes,
that person's GST is cancelled, but he has to obtain, he can obtain a fresh rate subject to payment of,
yes,
Yeah.
that is
and maybe the process he may lose some input tax credit, benefit, whatever.
Yeah.
But as per my
Yes, ma'am.
uh, answer.
Much.
How about it? Stops. Then we'll resume after 2-3 minutes. 2-3 minutes. We'll resume after 2-3 minutes.
Yes.
We're in IA.
Yes, we are in IA.
My lord, virtually, if you decide the IA, it is deciding the whole case. That's my like, your lordship will take a call on it. IA is deciding because IA hears the file for modification variation of the order. Now nothing will remain. If suppose today your lordship is satisfied that this is a matter where we will decide, interim will modify the order to the extent that let the interview continue.
Okay, let me read the first order itself, which
Yes.
is required to
Yes.
I have annexed in my IM. Page 16, my lord, and IM.
answer to the contentions recorded in the order. I think that decide the.
Yes, whole case.
It will-
That's not my view.
Oh, my
They have not filed any.
Okay, we'll hear it.
My lord, why I am submitting your lordship can, because normal post is lying vacant.
Right, right. I am concerned with that also. This court is also conscious of this fact.
May I submit? The post is lying vacant. Now, my lord, take with manpower shortage for the agencies, my lord, facing trouble. That's why, my lord, I
Absolutely.
just, my lord, your lordship kindly modify the subject to result the petition, my lord. So that will do, my lord, your lordship kindly see. Prima facie, my lord, your lordship kindly, their contention is that, my lord, the person who formed the outlying means they are not entitled. Why? Your lordship kindly, outlying means, my lord, they are only in the same service, my lord. This is rule is applicable to outlying means also, my lord. High Court service, my lord, the post which is created by the government of Assam, there is only one post, for that is for the principal seat. That does not mean that the person who is from outside will not entitled. It is put honorable.
No, firstly, just highlight that what is the promotion, how the promotion are affected in principal seat
My lord.
and the outlying bench.
My lord. But
Because just my query, if you have the High Court rules, do you have the High Court?
Yes.
Let us, we have this one. Then come to say, for example, page 677. 678 and 679.
my lord.
How it is reconciled?
My lord.
How it is part of the High Court? But
My
I want the answer.
So these are also, my lord, these are the stand.
These are also posts.
These are the post and these are also under the same service rule, my lord.
Right. Right. I absolutely agree.
My lord. No,
There is no doubt.
my lord.
Now, Rule 17A. Can you produce any of the order passed under Rule 17A? 17A.
17. Yes, there is a transferable, my lord.
Can you place anything, any notification, previous notification?
From transfer.
Yes.
No, it is your lordship kindly similar that have
See,
to.
that is subject to a rider. public.
No, since rule is there, suppose none of them, my lord, till now it is minimum transferred. But rule is there, my lord, that can
So
be, my
till
lord.
now it is transferred or not transferred? Any
Yes, my lord.
earlier exercise of power under Rule 17A?
Yes, I don't transfer, my lord. You do under 17 of the 1, my lord, is transferred.
What is the condition there? Incorporate.
My lord, that I have to consult with the record. But my lord,
Because there lies the
no,
answer.
that so provision is there, my lord. So his provision is there, my lord. So, my lord, how dare my
So
lord?
just show me. These are post Kohima bench, Itanagar bench,
My lord,
Aizawl bench,
my lord,
and plus principal seat.
My
There are scheduled
my lord.
to the rules.
Up
Now,
to joint register.
yes,
Joint register established on only one post. That is in principal seat, my lord. So the past that Honorable Chief Justice, while post was sanctioned by the government of Assam to the principal seat, then it was approved by the Honorable Chief Justice that is posted in service. That will be just put in service. The person joint register going outlying also eligible for that post, my lord. Suppose, my lord, someone eligible, my lord, in outlying mass, can they deprive from this post, my lord? Under the same service rule, my lord. They say there is a convention. Conventionally, from 2015 till today, that is maybe filled up by the post from person from the here. My lord, there is no situation arise, my lord. Now there is a eligible candidate there, my lord. They also can join, my lord. But what right of the petitioner that they debar from, my lord, joining in that election selection process, my lord? Since they are eligible, my lord, under the same service rule, they have a right to do this, right to participate. That's why, my lord,
so why this 17A then?
17 is
Why
transferred.
17A? Please answer to that first,
Your lord,
satisfactorily.
any employee of the service high court, including those doing in the bench of the Kohima Implement Agora, may be transferred from one station to another in the existence of the power service.
Then this rule should not have been there.
No, it is in the capacity, my lord. It is for a
If it is
transfer,
part of the same service rules,
my lord.
then where is the question of putting the word transfer then, Mr. Mohanto?
No, my lord, this is for a transfer. This is not for a promotion and appointment, my lord. For transfer, my lord.
This has to be read together. The whole rule are to be read together.
My lord.
Now, why this is the this provision 17A? It has been incorporated later on.
My lord.
When it was incorporated?
It was incorporated, my lord. 1998, my lord.
What is the object and purpose for incorporating this?
This rule was in,
Because it is a rider in the existence of public service.
my lord.
Now, there are instances of exercise of power
My lord.
under Rule 17A.
My lord.
What are the conditions when such notifications are issued?
Yes, my lord, I have to say that report, my lord. But no, but I am submitting your lord.
Then produce still
Yes, my lord.
one notification at least that will
My lord.
clear the air
Yes, my lord.
cloud.
But even then, your lordship kindly see the post, there is only one post. When the history establishment is only one post.
There are other issues like say this notification. There are other issues, zone of consideration, all these are there. Those are chances of promotion. That is one. But let us see your eye. Statements and never been made in the eye. We are quite conscious that
My lord.
it is not that we are not.
That's why
But when a litigation
no.
is
but
before
your-
the list
your
is
lordship
before the
kindly
court, we have to
see,
decide.
Rule does not debar that, my lord, person from outside ground when they are not eligible, cannot came to in the zone of consideration. My. Because
I
since
accept your submission.
since that post is, my lord, fixed in the service, my lord. The person, my lord, outside, suppose someone, my lord, out in the island, they are eligible, they can they do it, debar, my lord.
one of the prime contention is 17.
my lord.
Right. Now, this is there,
No,
the condition is that the person from outside can transfer from one place to another. From principal seat also it can be transferred.
Fine.
Right?
no,
Now, what are the conditions attached? If it is suppose, if it is from one post to another, right? Transfer. 50, 70.
My-
No doubt. These are under services of the High Court.
my lord.
Then
No,
why?
if there is a provision for transfer, my lord, why they are not been eligible to, my lord, participate in the, my lord, commissioner post, my lord?
Whether that also suppose one person is from IJO,
Fine.
transfer one.
My lord.
Principal. As per the rules, there are different schedules.
My lord.
How this 677, 78, and 679
My lord.
are to be treated? Please tell.
No, if somebody willing, my lord, if somebody willing, because they are getting, probably nobody like to come to Guwahati because they are
That
when
is
some-
different thing. This why this three this 677, 678,
my lord.
and 679
My lord.
are to be treated vis-a-vis the schedule mentioned for the principal at page schedule 1. How it is treated? Whether it is part of rule 11?
Yes, my lord, that is also part of Rule 11.
How, no, tell me, because it is not there mentioned, not it is not
Oh,
mentioned.
that is not specifically mentioned there.
No.
Yes,
How?
that specific, but means, my lord, that 17A will
Can
cover
you
that,
get
my-
this? Can you get this notification? 1998.
1998, my lord. Yes, then that notification, my lord, I
1998 notification.
1998, it will 12/11/1998.
Yes, Mr. Dr.
But in case of, my lord, my lord, in case of your lordship, can say Registrar General is the one post. Suppose Registrar General is one post, my lord. But Registrar General post, my lord, in the only principal seat, my lord, and it is from the judicial service. But judicial service, my lord, separate cases and list been prepared in the outlying benches, my lord. But there is instead, my lord, one from Meghalaya, the Registrar General, my lord, he was been transferred and he has been posted here as a Registrar General.
Like that is what I
That is
want to
that was
show.
there, my lord.
That is show one precedent.
So that, my lord, assertion, that is assertion, he was
Just show one precedent. That is the document.
then that has to be collected.
Either
That is, my lord,
because to at least consider this as
because yes, additional is prepared
because
separately.
some doubts are there which
No,
can be
that's
cleared by
why
you.
giving that example that I know by from my personal knowledge, I have submitted.
There may be many
My lord.
notifications under 17A.
My lord.
So if I get to see one, I think that will be how
Right.
this transfer will be treated. Whether is there something that though he is transferred to the principal, but his seniority will be counted
My lord.
in that particular batch.
That
If that
No.
condition is there,
no, here,
then something
my lord.
is there.
But
Why
is it-
don't you clear the cloud?
My lord, yes, yes, one example I have given, but I am not placing any record, my lord. But regarding that,
Because-
I'll give.
Yours, one is D is 17A. D is 17.
70.
Ground D is 17A. Ground A is sanctioned by the Judicial Department, Government of Assam.
Government of-
Cost is borne by Government of Assam.
Government of
And this notification is part of the restriction package.
yes, my lord.
Let us
Part of the
Show me some example that assistant registrar of,
No,
say, no, just court can ask.
my lord,
Hey,
my lord,
I don't think court cannot ask very.
definitely, my lord.
That show me some that assistant registrar of the XYZ has been promoted as joint registrar in principles. That can be done.
My-
If it can be done, show some precedent. Show some
My
precedent.
lord,
We are in existence for 77 or 75 years.
my lord.
75. Or any order under Rule 17A.
Transferring. Remaining,
If
my lord,
something, some condition is attached there,
that notification regarding 17A.
order or no, one is that notification.
Notification.
Secondly, any order passed under 17, that will clear the air that whether his transfer, along with his transfer, his seniority will be counted in the principle.
My lord, that,
Am I
my
So-
understanding.
convey? Because question is there. At least the grievance, whether they have a legitimate grievance or not. We are trying to understand that.
That's true, my lord.
Whether legally
that-
tenable grievance or not.
That I am, your lordship kindly said the post of joint registrar is, my lord, very available in outlying lands. But post of registered establishment only one post. There is
Right.
no
That
question of
does not
transfer on
mean,
that.
that does not automatically mean that one can go up to the level of register. It is not open for everybody.
then you
It
know-
does not automatically mean.
No, then, my lord, your lordship kindly the person who are working in, my lord, outlying bench, their ultimate is, my lord, joint register.
Yes. Yes.
Then, my lord, their service will have to
Either
be-
this or that.
then,
Both
my
is
lord,
possible.
then,
Mr. Mohanto, both is possible. Both is possible.
No.
Why the word transfer then?
all right, my lord, I will clarify on that, my lord. But
Then
transfer
let
has
us-
no, my lord, here on this, this is on single post, my lord. In that post, my lord, transfer will,
Yes, single post. No doubt.
in service, there is a single post. And, my lord, that means the post which was created, my lord, in the service.
There
my
can
lord,
be legitimate grievance. Whether those are legally tenable grievance or not, that is a different issue. I am repeatedly saying.
My lord.
Question is, suppose one has reached in the principal seat. Because the transfer is in exigency of service. Yes, you can transfer. But suppose from the assistant register to be promoted to the joint register,
20.
one person, employee in the principal seat has to compete with 15 others.
Right.
And in the bench X, he is the lone one.
Correct.
Or maybe two. Or maybe he may have to
Correct.
compete with two. And he reached the post of joint register. Here, fighting with 500 others, he has reached the position of joint register.
So in that case, my lord,
Now,
you will be,
This post is for principal.
my lord,
It is clear.
the post is for,
For
no,
principal
that
seat.
is sanctioned by the government of Assam, not for the principal seat alone, my lord. There is no landmark, my lord, anywhere, my lord. That only that it post is, no, post of establishment is the establishment only in Guwahati principal seat. It is required in the principal seat only, my lord.
It is required in the
Yes.
principal seat because every other bench says that a post of register will suffice.
My lord.
For them, from
For them.
age 677,
My lord.
78, and 70, that post of register will be sufficient for them. And here there are number of registers.
The number,
Number of registers. And-
there are three outlines, have only one. In outline means deputy register, joint register, only one.
And it is a prerogative of the employer how to deal with.
Right.
Now, hey, you say that from the outlying benches,
My lord, there are instance of, my lord, it is clear that, my lord,
if any precedent is available, good enough. What is the creation?
Creation, my lord, you also will find in the main petition. Page 45, my
In the principle.
page 45, my lord.
Show me some absorption from outlying
From
pencils
outlying.
to principal seat. Any instances the institution is in existence for 75 years.
My lord,
The rules are framed in 1967.
96.
So there might be precedent,
My, uh,
and that will be
give me some time, my lord. But that
because otherwise
this creation is, my lord, has your also 10th August 2015, my lord.
Hmm.
So that creation, my lord, by way of, my lord, there is endorsement of the, my lord, honorable Chief Justice, my lord. That is page 8, my lord, as the endorsement of the Chief Justice, my lord, how it put in the service. Page 8. Other side, as and this is the, my lord, agenda, my that is the deputy. Usually,
You make a statement.
Fine.
These are all part and parcel of similar. all the employees of the other benches and High Court principal seat, all are employees of the same High Court service rule. Then we'll pass the order. If this is make a statement. That's all. Nothing is required then. Nothing is required.
My lord, I have nothing to say also.
Then
And this
they have no case.
My lord, I am telling you, my lord, this is a-
Absolutely no case.
my lord, I
That was the consideration that your lordship
Then please make a statement.
and my lord, another point your lordship made, my lord,
That will remove all the clouds.
my lord.
That will remove all the clouds that all employees covered under
Same
irrespective of their outlying benches,
Well.
part of the same service rule. Then everybody can be considered for the next higher cadre of the post.
Well.
That's all.
Well.
If that is so, then there is no issue at all. They have no.
Another query your
Make
lordship,
a statement.
another query your lordship made, my lord, that there is a promotion in that,
No,
this
that will not require that. This statement is enough. This statement will be enough.
tomorrow, my
Make a statement. I did it.
in respect of all the cadres and employees,
Okay.
all the cadres and employees,
Because
not
that is
only
the view.
registered.
That is a view.
there is a
So, make that statement and everything is clarified. That why these schedules are required, that is a different thing, administrative purpose.
And-
But for ideal bench, LDA, he can be promoted to UDA in principal. LDA from principal seat, he can be promoted to UDA in Itan. So everything is clear, crystal clear.
Well.
Everybody will be liable to be transferred everywhere.
This will be,
This will be
my
for
lord,
the administrative benefit for all.
my lord.
Make it-
I
make
I
it
have
then-
seen, I have filed an affidavit also, objection. I have annexed by an RTI, I brought the resolution of full court. Full court I have brought it. 3 of the judges and 1 of the chief justice. Why this principal seat, what has been used?
Wait.
My lord, I have annexed it. Objected. My lord, I'll just tell one thing. Before that, my lord, your lordship was absolutely, I noted down. 3 of 676, this page 677, 678 and 679.
I have some doubt.
No,
That
no,
is
that's
why-
absolutely, no, my lord, I honestly, my lord, if they come and say that it is one and is a common gradation list, even they have a separate gradation list, all employees will be together one and promotion will take place between all of them. But that was not the intention of preparing of all these schedules. Other it will be chaotic, but I have seen Agartala. Agartala is now separated, Meghalaya has been separated. Now cadre post they have created. Kindly
Because
see
this
Agartala,
confusion
my
has
lord.
arisen in the mind of the court only
No,
for that
this
purpose.
is, my lord,
Because see, schedule 1 is there. Right.
yes,
When
schedule one.
Agartala was part of
No,
this,
Agartala, kindly see,
see page 670.
yes, page 670,
670.
670, pay and cadre. Pay
Right.
and cadre of Guwahati High Court, Agartala bench.
It was part of Rule 11.
Yes.
Right. And Schedule 1D,
Correct.
670. When Agartala was part of this. Right.
Right.
So there is a Schedule 1D, Rule 11. But conspicuously, these are not there in page 677, 678,
See, not
679.
there.
Part of Philip,
How this has come, I don't know.
Right.
Right. These are just queries.
my lord, I understand, my lord. No, it is better, my lord. It is resolved for one for all. That is better, my lord. But my
How
lord,
these are there in the High Court rules. But unlike
no, that means, my lord, that these are also the part of the whether it is page 678 and 679 is a part of the rule.
My lord, one simple.
because
My lord.
their pay and allowances are governed by the
Their
state
respective
rules.
state,
State rules,
state rule.
right? The joint register here enjoy different benefits,
Yes.
My lord.
and the joint register here enjoy different benefits as extended by the respective state.
Right.
Because so far as pay and allowances is concerned, it is the concurrence of the state government, not the High Court.
My lord.
High Court will suggest and state government will concur.
My lord.
I think Article 225 or 229, maybe.
220.
So these are something which, and why this schedule are required? Everything should have been included in main one.
Schedule, my lord, probably their respective, my lord, the state government has, my lord, paid their salary because in Arunachal pay is more higher than Assam, my lord. That's why they don't like to come here.
Well, it is, my lord, for example, in 678, if your lordship finds the post of assistant registrar, thereafter promotion takes to deputy registrar. Now here the rule says merit comes seniority. Now suppose one of the person here in the principal seat and from Arunachal Itanagar, the merit is same. Now the question of seniority will come. So how seniority will be determined? A person born in that cadre and person born in this cadre, oh, there is a hell of a difference, my lord. With great respect, I am saying. And there is a judgment of the Supreme Court. I'll place it, my lord. If that is not cleared in the Guwahati High Court rules with great respect, 17A, my lord, is only meritor. Now your lordship has put a very pertinent question. So one example where one person has been absorbed. I have given a chart. My lord, kindly see that in the read petition. I have
Have you
not-
annexed anything like
see
order?
59. Now it is written there itself. See 59 of my read petition.
59 of it?
59 of the read petition. See, my lord.
Yes.
Now, my lord, kindly see 2. 2, if you go down, credential list of deputy in Guwahati, Itanagar branch. Lordship got it? Now see the column. This man is Ravindranath Burman. Kindly see Roman 3. Transferred to Itanagar bench and join as deputy registrar on so and so. Not yet absorbed in the registry of Guwahati or Itanagar bench UPR. Because as I have got a read petition, it was some punishment, some posting, it was transferred. Till today, it has not been absorbed. As on date, they cannot absorb with great respect. Unless your lordship has to say what else, put a common, no problem. Because all state, all outlying benches have different gradation lists. See, my lord, if this gentleman is absorbed, now the post which someone is holding, the post of deputy registrar, my lord, is gone. That's what your lordship is worrying. Now today, this on the principal seat, there are so many employees in principal seat. What was the need of this, the registrar establishment? They made a representation saying, see, I come to the post of, and their joint registrar is free. And all other outlying one joint register. Pay scale is different. My lord, the intention, if 17A would have been specifically or by some amendment that it will apply so promotion is concerned. Absolutely no problem, my lord.
Right.
It is
Because
not
my
clear.
anxiety is that suppose here we have 3 joint registers.
Right.
Suppose.
Yes.
Now one fine day, order is passed. Let them be transferred. Done for him.
In
They are
joint registrar-
permanently there
in joint registrar level.
in joint register. At the same post. Under Rule 17A. They are there for next day. What would happen to all the have you got
So, yes, I understand that point. But equally, your lordship kindly.
so other way around because here you have brought 3 within the zone of consideration. No issue. Along with 3 from principal.
Fine.
6 initial. 1 retired. In the mean.
Already in the
1 otherwise initially what was thought of 6. 3 plus 1 1 1. What if the other way around for the post of joint registrar? 1 somewhere in bench act. Put all 3 here from SC register or all 5 or 10 of them in the zone of consideration in bench act.
My-
Have you
I understand.
1 post of joint register is available in bench act. to be
Only
filled up.
in outline means only one, my lord.
One assistant register from all events. Put all 10 from here in the zone of consideration. It makes it 13.
Right.
All 10 assistant registers will be eligible to be inducted within the zone of
Right.
consideration.
Right. But-
in bench X. No, I'm hypothetical.
Yes,
Hypothetical.
hypothetical. Such situation
Hypothetical.
not
Whether
arise here
that
now.
no, whether that is possible.
My lord.
If that is possible, this is possible.
No, your lordship kindly see the person which is, my lord, got the joint register in, my lord, long back in outlying bands. Suppose. Since he has no promotion, my lord, respect, my lord. Now he is, as per the rules, he is eligible, my lord.
Constitution says at least maximum 2. It should be minimum 2.
My lord.
Constitution, that all the decisions now, where there is no promotional aspect,
My lord.
there should be at least 2 promotional avenues. That everybody can go to the top. That is not the constitutional provision. The constitutional provision that if there is no promotional avenue in a particular cadre or service, at least constitutional requirement that at least there should be 2 promotional avenues.
Already, my lord, yes, that is true, my lord.
That principle is also there.
My
Maybe one in the one particular hierarchy, that this is the maximum post you can achieve. That is a possibility.
My lord.
Now, just that cloud is to be removed. Anything 17A, any order that,
My lord,
My lord,
I- I-
and
I-
plus that
outline,
notification.
outlying benches in somewhere in, I think, 12/8/2000 in Itanagar bench and Aizawl is 5/7/2000. That's then there was, that's I have been told, right? That there was an option. That you want an option to go to order, you can go. Some posts were created by the respective state government. All those, your lordship will know better, all these outlying benches like Itanagar, like your Aizawl bench, these were all created.
time of
So, my lord, their creation, there is a meaning of it. Your lordship will expect, that's also I thought, that if the rule is very clear about it, then there was no question of these particular, those schedules in Agartala that in consonant with Rule 11. But so far other is concerned, it is silent. They have not mentioned anything. So all these posts, now I have been told the post of registrar is the highest in outlying benches.
Okay.
But these are to be filled up by judicial officers, not by the ministerial
Maximum-
staff. No.
Maximum, otherwise, if this is prohibited, suppose
Yes.
filling up the post of register establishment is prohibited for them, then they can reach up to joint register.
Yes. Yes.
Otherwise, we are testing the other issue, that the remaining, that they can also be inducted as and promoted as
But they say-
registered establishment.
My lord,
Now,
yes, sorry.
now, any order, suppose Rule 17A is there. If all things are joined, then why this transfer from one to another incorporated in Rule 17A? That is why one is place of posting, right? But whether with or any order under Rule 17A is with a rider, that is what I am. No. Am I clear?
Michael.
Am I clear? If any transfer is made in executive permit, okay, that is the prerogative of the employer. But suppose the act is transferred from Guwahati to Kohima, then whether he is part of the any other condition attached in that order. Am I clear? If some condition is attached, so say for example, what Nasir said, that this
Form.
he has been transferred to Itanagar, but he is not
Included in that there.
So, what is his transfer order?
Probably he is highly read petition and coming back to this.
No, what is his no, but I'm not interested. What is the condition in a transfer.
I have to advertise it.
Just these are only, if this is correct, you make a statement on that. The basis.
The order
Even
on-
thought about modification or not.
If this is correct, then the three judges, the highest three judges sitting, my lord,
But there are
It
other minutes also. But if we make the statement,
administrative decision taking, my lord, at page 51 I have annexed. Clearly it is written, the High Court staff of the principal seat and outlying benches.
which one?
At page 51 of my objection of their application for modification variation of the order. 51. See 51. my- See, my lord, that committee, I made an RTI. Committee, my lord, this is very important.
Hmm.
Committee for dealing with all matters relating to officer and staff of the High Court principal seat and outlying benches. Lordship got it?
51.
Page 51.
51.
Yes.
Three judges. Now the committee, my lord, bracket, committee for dealing with all matters relating to officer and staff of High Court, principal seat and outlying benches. Now kindly see, the matter relates to the filling up of antecedent vacancy of register established in the principal seat of the Guwahati High Court.
Hmm.
It may be mentioned here the proposal was sent to the state government for creation of one post of register establishment to be filled up from the officer of High Court service, since no officer from High Court service was represented in the rank of register. Accordingly, the post of register establishment was sanctioned by the state government. So and so, Honorable Chief Justice, by order dated 13/8/2015, directed to fill up the said newly created post register assigned by way of promotion from the cadre of Joint Register Class 1A in the High Court service from ministerial stream and stenographer stream. Thereafter, the Honorable Committee on consideration of the service particular and other relevant matters of Joint Register from ministerial stream as
Hmm.
well as stenographer stream of Guwahati High Court principal seat recommended promotion of Nair Joint Register stenographer stream to the newly created post of register
This
established.
goes contrary to
other-
So these were the minor, and in 49, these
one
and
minute.
Chief
One
Justice,
minute. One.
yes, your lordship can go further below also. It is pertinent to who is holding the post register will be retired from High Court service, age of superannuation. The matter was laid before the Honorable Chief Justice Lordship by order dated direct to place the same before the concerned committee for consideration parameters, norm fix of promotion of officer and staff to the next higher post as notification may kindly be seen. At present, there are 3 registers in the register for ministerial stream and stenographer stream who are eligible to be considered anticipated vacancy post of register. Therefore, the name of existing 3 registers from the ministerial stream as well as stenographer in the order of seniority in the rank of joint register are given below the concept for the promotion, so and so. So all these 3, my lord, are from the principal seat. All these 3. Name of the qualified present register is so and so. Number 2, C. Nara NP Joshi, joint register, stenographer, his principal seat. Number 3, Abdul Motif, joint register. These are principal seat. It be mentioned, no SCR has been documented for the year in respect employees, as most of reporting, reviewing exam are recorded ACR for the year 2012. In regard, a note was laid before the Honorable Chief Justice, which may kindly peruse. Remark, proposal for filling up the resulted vacancy may perhaps be placed after filling up the aforesaid antecedent vacancy of register establishment, as because the names of the officer, both the stream as well are in the zone of considered promotion to the said post of register establishment. So register, these are the joint register is one particular relation list. They cannot come from Itanagar, they cannot come for that particular place. And this was created. Kindly see, my lord, at page 49 by the Honorable Chief Justice. Thereafter, this post was created at page 49. Noting of the Honorable Chief Justice at page 49. Kindly see the first sentence. This is regarding filling up the anticipated vacancy of the post of register of Guwahati High Court bracket principal seat. it is pertinent to mention post of registrar were created by letter dated 10/8/2015 to fill up the joint register of Guwahati High Court principal seat. Accordingly, the Honorable Committee on consideration of the service particular other relevant material of joint register from general stream as well as stenographer stream of Guwahati High Court principal seat recommended promotion of so and so against the newly created post. It may be mentioned S.T. Nair, who is holding the post of registrar, will be retiring on superannuation 30th November. In view of the above, filling of the antecedent post of registrar may perhaps be considered. Service particular of the eligible officer of general stream, stenographer stream in the order of seniority or rank of joint registrar given below for consideration of their promotion to the antecedent. So these are all from the principal
Mr.
stream.
Mohanto,
My lord.
their objection. Now, please come to page 53 to 53
My lord.
to 57. Whether in any of those 4, 5 occasions,
My lord.
this kind of procedure as sought to be adopted in the present case were adopted. Page 50.
Page 50, 53, my lord.
One was promoted to register establishment in 2015, right?
My lord.
Now 2017, next page. Another joint registrar was promoted. Then page 55,
My lord.
another joint registrar was promoted. 56, another joint registrar was promoted. And page 57, another joint
My
registrar was
Earlier it was not.
in all these 5 occasions.
My lord, only 5 occasions is from principal seat. That is principal seat. All,
Why no, it was
because
not?
on that, my lord, I have taken instruction. But my lord, your lordship
Then
kindly
put
see
it
my
all
lord,
the,
there is a
all the,
convention,
all
my
the,
lord. No,
all the minute. If on 5 occasions it was not considered,
my lord.
and how he can accept?
No, in my lord, only that his post was, my lord, created by the government of India, post in service. That's why, my lord, earlier it was not. It is a convention, my lord. It is conventionally.
No,
Conventionally, it
convention-
was.
Convention is backed by on 5 occasions.
My lord.
It is not a single occasion.
My lord, I understand, my lord. Now, my lord, since it is, my lord, post in service, my lord, equally, my lord, they have also, man, we cannot, can we deprive them, my lord?
No, we are not.
they are eligible, my
we are not into deprivation.
No, if they
We
are,
are also
no,
into
that
practice.
mean, my lord, if your lordship
Show
hold
me
that
anything
this
on
post is
17A.
if your lordship hold that this post is only for the
No,
principal
I am
seat,
not hold. I am
and my
trying
lord,
to, Mr. Mohanto, we are not into anything. We are trying to
My
find
lord.
out the.
yes, that is true, my lord. In earlier
I am
five
not
occasions, my
concerned
lord,
with anything. We want to know actually what are the provisions of law and what are the practice followed. All this.
my lord.
We are not here or
No, my
not
lord,
here.
earlier occasion, such
We want
situation not
to
arise, my lord,
decide the issue. Mr. Mohanto, any
in
confusion?
earlier occasion, my
We
lord,
want to
such situation-
decide the issue.
no, earlier,
Not that, and I am conscious of the fact.
my lord, earlier occasion, may
It is not to
such
be
situation
argued.
not arise, my lord.
Any order 17,
My lord.
put it to more.
Fine.
Day after day,
They have
any
not
day.
reported that.
We go on day-to-day hearing. So until all the doubts of the court is clear. Because you have not filed any affidavit also.
No, my lord, I have not had an affidavit, my lord. Actually,
It's also very difficult.
my lord, our free intention
Because-
was that,
Practice followed till date is different.
my lord.
Admitted.
Exactly, my lord. Admittedly, my lord, earlier
So
occasion,
this situation has arisen because of
right now,
right. Otherwise, practice followed it was different, and the rules are not very clear.
no,
And
and that
and
in
and,
that
and,
point we
and
are
the minutes are also admitted. What I have seen,
I have placed, my lord.
what I have seen, and what was there previous, those are also admitted.
Right.
So everything has come to the court. One line of argument and different line. can
Yes,
put it tomorrow then.
Tomorrow
again day
is
after
better.
tomorrow.
Doing
So that
tomorrow, let it be tomorrow, man.
tomorrow by this time, my lord, I am not unable to find.
No,
the
tomorrow,
due.
High Court is here.
will
Maybe here, my lord. I'm,
No, no,
that's why I'm
court,
putting this tomorrow, my lord.
on the since you are also expecting I will put it tomorrow again
Yes.
day after tomorrow. No,
All right,
Yeah.
tomorrow, my lord.
tomorrow in the second half. Put it.
That's why, my lord, your lordship kindly heard the view from this honorable court, my lord, because it was
So that subject material should be there also.
My lord, one thing with greatest
And it
respect.
should not be inconsistent with whatever notification, whatever was there. My only anxiety is that. Force anxiety is that it should not be unknowingly at variance with some notification,
my lord.
some order.
No, that
My lord,
since 2015, we have to see all the notifications, my lord, because it is created in 2015.
Well,
Followed and the
By the
other
assembly.
minute of the committee
My lord,
is apparently at variance with
and the present, I have not gone for the others point on the.
no, it is there.
Yes.
Yes,
That
yes.
is two I have seen.
Yes,
Is in respect of NIAR.
yes, so that minute is at variance with
Present one.
so which one is correct?
my lord, only one, my lord. It will have a great ramification. Suppose wrong on my part to put something and it will affect the whole system. I think, my lord, we have to be very careful on the issue. I may lose a case or he may lose a case. Because it will have a great ramification on
Yeah,
all the outlying benches. Not this one post.
Because
One
I want that statement from you that will clear.
Regarding one
It is
point,
up to you that it is one and all. But the minutes has observed.
even otherwise round, my lord, if your lordship decided that this post is, my lord, only for the principal seat, my lord, that is also, my lord, that will, my lord, matter will be resolved, my lord.
For that sufficient material
That,
should be there.
that matter will be resolved. That only
that
that post is only
sufficient
affected by the,
So to hold that also,
my lord,
sufficient.
my lord.
Those notifications.
My lord, I
17A,
I'll definitely.
region for incorporating 17A
Yes.
and orders under which 17A are passed in exigency of service attached with any condition. Because say for example, Bormon State is there, but he is not yet part of the case. Part of that.
My lord.
If he is treated to be alien, stranger, then issues are there.
But the committees, my lord, because they may be paid, my lord, but it has to be, my lord, with the consonant with the rule. We have to see. We have to see that with the. Now you have to see with the procedure of the rule, that condition of the rule.
But they cannot,
Because, my lord, administrative committees, my lord. sometimes,
my lord,
it's difficult. Very-
they cannot come and say 17A is only applicable to registered establishment. So for other is concerned,
DJ Mohanto, it's a PP for the opponent. Please check. Tomorrow.
Well-
Some doubts which are to be cleared, then we can interim order.
there is
Shall
interim
continue.
order.
Service has been completed.
Hmm?
Service completed.
How many respondents? Four is represented by Standing Council Education.
Yes.
One. Okay, where is Standing Council Elementary?
And border. Which and
The
border.
name is not reflected.
Well, in
Name is not reflected. 5, it does. What about 6?
6,
This is absconding, my lord.
Huh?
Absconding. But
That okay,
no service has been completed upon
right, services. Now, what about 2-3?
20, my lord, bank, my lord.
31 feet cross feet. 31 feet thousand. Now, who appeared?
20,
Or bank?
20 appeared, my lord.
No, who? Name is not reflected. Sorry. Names are not reflected. Who was the counsel?
M. Sharma.
Okay. His name is also not reflected. No. Right. Here. M. Sharma.
Yes.
Heard Mr. U.K. Bormon. And it's also put up petition. None has appeared for the point number 5. 2. The name of the learning for the response number 5 is reflected in the as per order dated 22/8/2020 of the Lodging Code, comma, the service of notice upon the response number 6 is complete. Right. The name as per order dated 13/5/2024 of the Lodging Code, comma, the service of notice upon the response number 2 is also complete. The names of Mr. M. Sharma and counsel for the response number 2 and 3 and MS N. Bordolo and standing of elementary department, education, within bracket elementary department for the respondent number 4 be reflected in the respondent side record. UK Burma and M. Sharma. I would have, yes.
I'm appearing on behalf of 2 and 3. I've got an instruction.
How much instruction? How much time? Freezing of account.
Your Lord.
Freezing of account.
My
Freezing of 2 weeks. Maybe.
Mr. Sharma. Learning counsel for the respondent with has wait for any message which time it start obtain the instruction as regards the matter of freezing of the bank account of the petition. Please start on ED.
interim prayer may be considered on the next day, my lord. Prayer for
Let
interim.
him come with the instruction
Yes, my lord.
after the 5 things.
On earlier order, it was reflected that it will be considered on the next day.
Hmm?
That's humble thing. Order is
Thereafter, it is not reflected in the next two orders.
thereafter nothing. Because deep level.
I remember I have heard it at some length, but I have forgot.
A lot of
Long
water
back,
has
perhaps.
flown down the bridge, Lordship.
Huh?
A lot of water has flown down the bridge.
Yes, yes.
Since Lordship has joined
No,
the
if
matter last.
there is any note, I am trying to find out. If there is any note, because thought that I made some notes. If that is available somewhere. What else? Yeah. Pages are marked.
My lord.
Okay. Just recapitulate
My lord,
at first.
as per the industrial policy, the new industrial unit, as well as the industrial unit which were undertaking substantial expansion, were entitled to benefit. Earlier, modernization was also included, but in the 2008 policy,
2008.
my lord, the modernization was not included.
What about 3? 2003?
Three, it was there, my lord.
Let us see 3 first. Then you started with page 31 perhaps.
The three policy starts at page 31.
31. And modernization. Page
You'll also find it page 38. Modernization was also there.
definition. Page 37.
So 37 is the expansion, new unit definition. Thereafter, you'll also find the eligibility criteria at page 41, 2.4.
Let us have this modernization definition.
My lord. Well, you'll also find page 38.
Right. Right. New
2797.
having that proviso to just below
My lord.
modernization.
My lord.
The incentive available
My lord. To the
the
unit,
unit undergoing expansion or
modernization
diversification.
shall be for the additional investment made. There is no dispute about it, my lord.
No, that's just
My
no
lord.
dispute, but to put
For
it
the
in my mind.
additional investment made and for the increase in production over the average of 3 years prior to the year when the unit goes for expansion diversification as applicable. The year this purpose shall means a financial year. That means below the by undertaking the modernization diversification, whatever increase in production is there in comparison to last 3 years, and subject to Milord the additional
What is this 3 previous years prior
the
to
base
the
year,
year?
Milord, the year in which the modernization is done prior to that 3 years.
Okay, that means suppose, say, previous 3 years, average production is say 100 units.
Right.
Then it should be minimum 125.
125.
Simple arithmetic is that. Okay.
Milord, in this case, in fact, the whole dispute which is arising for Lordship is that the operational guidelines which were issued, by which the modernization was also included within the substantial expansion. It was said the modernization will also be covered by the substantial expansion. Now the same was approved by the government. The operation guidelines were approved by the government. Now,
Actually, I have forgotten everything.
well, I have just looked. Milord, in fact, in the 2003, 2008, Milord, modernization was not there.
Okay, no, otherwise 2007,
2003,
expansion was there,
2003, Milord,
2003,
My lord.
diversification was there, and modernization was there.
my
And criteria for all is same.
same.
Diversification, criteria, modernization, expansion.
My lord.
Expansion is what?
Expansion,
Industrial means additional fixed
fixed
capital
capital investment,
investment exceeding at
25%.
25% of capital investment of the existing unit
My lord.
or a new unit. It is also capacity also.
My lord. In the present case, these things are not disputed.
Now we'll come to that.
If you
Now,
look
what is the eligibility criteria? Page 41.
41, Milord. It says, Milord,
You will be existing unit.
existing.
You will be existing unit,
My lord.
not new unit.
No,
Going for expansion,
we said modernization.
modern.
Right.
Modern. Okay. Shall be eligible for. This was in 2003,
Three.
page 41.
My lord.
Only against the additional investment made for modern. Okay.
Now, Milord, thereafter, the 2008 policy came, Milord, at page 57.
What was the benefit in 2003?
But the benefit was the same, Milord. With the 7 years exemption, I will just place it for
7 years,
at page 47.
subject to maximum of sales tax exemption.
Wait, Milord, sales tax. At that time, Milord, it was sales tax
That is the benefit.
benefit. Apart from other benefits, Milord.
Now, page 57.
My lord. It policy from start page 57 and Lordship may kindly see page 81. Clause 4.6.
Yes.
There the modernization was not there.
Modernization was not there.
Thereafter, Lordship you can see page 101.
So what was included?
Lord, this was the expansion.
Huh?
Melody Lordship see eligibility criteria. A unit that is engaged in the manufacture of the so and so, your Lordship will find
Which
further.
clause you are reading?
Page 81, clause 4.6. B, my lord. New units set up on or after 1/10/2008, as well as the existing units undergoing substantial expansion at the same location, same place in the same state of Assam on the after 1/10.
Substantial expansion has been defined.
Substantial expansion will be defined, my lord.
Let us see.
That your lordship will find at page 81 itself. 4.53, my lord.
And
Now I may take your lordship to page 101. Clause 12.4.
point?
12.4, my lord. The decision of the Industries and Commerce Department of the Government of Assam with regard to the interpretation under this policy shall be final and binding. Thereafter, lordship may also see 2.6
Guidelines
guidelines.
and procedure.
A set of guidelines including application norms, procedure for getting various incentives will be issued separately.
So 103.
103. So operational guidelines. And 106 is the relevant part, my lord. Substantial expansion.
Yes.
And you'll also may say in the middle from bottom, my lord. Also process modernization. Thereafter, also may see page 109.
So, what do you say about process modernization?
My lord, 107, my lord.
What do you say about process modernization?
Process modernization, it is, my lord, at page 106.
Yes.
Also, process organization will be constituted. Separately, identification investment made by an existing unit or a new unit in the fixed assets involving new improved technology having definite advantages in reduction of the cost of production service standard, provided that the additional investment on fixed assets is not less than 25% of the gross value of the fixed assets.
So substantial expansion includes process modernization.
This was the process guideline.
Okay.
I will also kindly see page 109. Eight Milo.
109.
The state government department organization related to the implementation of the industrial policy of Assam shall issue certificates, registration, clearances, NOCs, etc. required for granting issue to the unit expeditiously for application or application by and depending on its eligibility or such certificate for meaningful implementation of the policy. Now at page 171, these guidelines were approved by the government of Assam. At page 171, the policy guidelines, the guidelines were approved. Now, my lord, at page 172, the petitioner gave a prior intimation in respect of the modernization which was going to be undertaken to the Managing Director, Industrial Development Corporation.
You are running asbestos unit.
My lord.
So you made this intimation under industrial policy 2008.
My 8.
Okay.
Now, at page 173, my lord, the project report was submitted. After submission of project report, my lord, at page 179, I submitted the application for issuance of the eligibility certificate. Page 179, my lord.
Yes.
Now we'll also kindly see page 190.
190.
My lord. The application was forwarded to the Commission of Taxes for comments.
By MDA.
Well, that is implementing agency. Now, my lord, at page 191, an inquiry report was there.
By the AIDC.
My lord. And Lord, may kindly see page 193, the last paragraph. Thereafter, at page 195, my lord.
Yes.
Commissioner of Tax gave reply, your lordship, you see the last paragraph, my lord.
Your observation is second paragraph. Let us see.
Well, that is, my lord, it tells, my lord, as regards the views of the Assam European Summit to be
Because
the drafting of industrial policy 2008, the process of diversification and modernization was also proposed for exemption criteria. In this respect, the furnished our views to the government. Accordingly, the government sent views to the industry department by letter number so and so. Thereafter, the industrial policy of
what
2008,
is this government?
my lord, that they filed an affidavit, my lord.
No. Accordingly, government sent views to industry department.
My lord.
What is meant by government?
My lord, the Commission of Taxes sent the views, finance department.
Because government sending it to the industry department.
send
Both government, both are government.
My lord, both are government.
Which government?
My lord, but it says, my lord, the views of the government.
Huh? Right. Which department?
This is finance department.
Finance.
Finance to the industry
Okay.
department.
Views by government different numbers. So the dispute starts from here.
They say, my lord, that in fact we send a views, and after that the modernization was dropped.
After the state definition, substantial expansion was included, wherein there is no mention of
Modernization,
diversification or modernity.
my lord.
We frame tax exemption justified as part of the 35 for then last paragraph, therefore the definition
My lord.
of
Substantial
substantial
expansion included in the operation guidelines, which was approved on so and so, is not in conformity with the principle laid down in the industrial policy of 2008. Hence, without amendment of the Assam Industries Tax Concession Scheme by the government, the criteria of modernization cannot be considered for the purpose of tax exemption under the said scheme. After the policy, a scheme is framed to give effect to the promises made in the industrial policy. That is by way of notification issued under the tax statute. Now the commissioner is of the view, first of all, he says that the operational guidelines which was approved by the government was not in conformity with the industrial policy.
So according to them,
My lord. According to Commission of Taxes,
substantial expansion
my lord,
does not include
modernization,
diversification or modern.
my lord.
That is their
First view.
first view.
Secondly, he says that the scheme has to be amended because the scheme was prepared on the basis of the policy. Now, at that time,
Scheme means tax exemption.
exemption scheme. That exemption scheme is to give effect to the industrial policy resolution. Now, at the time of framing of the scheme, the guidelines were not there. So the scheme was prepared according to the policy. Now the commissioner says that has to be amended. Without amending that, the exemption cannot be granted.
So policy was notified in 2008.
Eight,
Tax exemption scheme was notified in 2009.
9,
Operational guidelines were approved in 2010.
10.
This is the sequence.
Right.
So in 2012, they are writing
My lord.
that since on the basis of 2008
Eight.
policy,
Right.
the tax exemption scheme was framed in 2009
Right.
and the operational guidelines came in 2010. So this tax exemption scheme was to be amended to include that to
Modernize.
that substantial expansion should include diversification
and modernization.
or moderation. In the absence of any amendment, no benefit. Or modernization. That is perhaps the
Right.
view. This is the, I think,
Crux of the-
purport,
this is the crux of the issue.
purport of this
My lord,
particular letter.
my lord.
Okay, let us read it once again, last paragraph.
Last paragraph. my lord. Therefore, the definition of substantial expansion included in the operational guidelines, which was approved on so-and-so, is not in conformity with the principle laid down in the industrial policy of 2008. Now, one question which I am asking you, myself, he is the Commissioner of Taxes, is the functionary of the state. Guidelines were approved by the government. Commissioner is not the government.
Hmm.
Now, Commissioner is saying that the approval given by the government was not in conformity with the industrial policy of 2008.
Okay, that if now I remember, 6/11/2008 I asked for, right?
My lord,
Where is that? It was presented, I think.
There is an affidavit filed by
they
the
filed an affidavit.
Just
Before that, I may just
now it has flashed in my mind.
Right.
6/11/2008.
now thereafter I have annexed the scheme, which is my lord not
This is
required.
6/11. Now I have. Is 383. No, that has been corrected. That has been corrected. Now 383.
Well, before that, if you also make just these facts, thereafter you'll also look into the affidavit.
No, I'm not looking to their stand. One, what? Just yes.
At page 203, my lord, 5, my lord. This is a letter addressed by the managing director, AIDC, which is the implementing agency, to the principal secretary to the government of Assam, Industry and Commerce Department. Now, we'll also kindly see the para 2. There is no mention of the industrial policy of 2008 about the existing units undertaking modernization. However, the operational guidelines approved by the Industry and Commerce Department include the provision of modernization unit as the process modernization will be constituted as by separately identifiable investment made by an existing unit or a new unit in the fixed assets involving new improved technology having definite advantages in reduction of the cost of production services rendered, provided that the additional investment in fixed assets is not less than 25% of the gross value of the existing fixed assets. It also may also be noted that the units undertaking modernization were entitled to the incentives under the industrial policy of Assam 2086, 1991, 1997, and 2000. It should be 3 million,
Yes.
mentioned
Just
only.
one.
The corporation, therefore,
Just a minute.
my lord,
Where is that process modernization?
my lord, that is operational guidelines, my lord,
Page one again.
page 41.
Page.
I'm just giving them. One of the page. 103 minute starts,
103.
my lord.
Of that word where it is.
And modernization, process modernization, you'll also find page 106.
Yes.
Now, the MD thereafter says, my lord, the corporation thereafter, therefore, after scrutiny of the application, inspection of the unit, and the examination of the documents, had forwarded this report to the Commissioner of Taxes and eligible case for consideration, as a eligible case for consideration of the grant of EC under modernization ahead of the substantial expansion. Thereafter, my lord, the Joint Commission of Taxes by later dated so and so informed that the case is not eligible as not fulfill the criteria of operating at least of minimum of 80% capacity during the period of the previous year. The corporation by later dated again informed the Commissioner of Taxes that the case was scrutinized in the light of the operation guidelines framed in terms of industrial policy of Assam 2008, wherein the process modernization is defined as under as para 3 above. Thereafter, my lord, again it is reproduced. My lord, second paragraph. It is to be mentioned here that the above criteria is for existing units undergoing expansion, which are not applicable to the expression undertaking modernization as per the operational guidelines for the industrial policy of 2008, and the Assam Roofing Limited do fulfill the requirement of the guidelines issued by the government of Assam industrial policy of 2008. Thereafter, my lord, the last but one paragraph, my lord. The case was placed in the 5th SLC meeting of the AIDC for grant of EC under the industrial policy of so-and-so, on so-and-so and so-and-so. The matter was deliberated upon and it was decided to refer to the government of Assam, the state level committee of AIDC for grant of eligibility certificate under the industrial policy of 2008. After deliberating on the agenda number so-and-so, the proposal of the Assam Roofing Limited so-and-so for grant of EC as an undertaking modernization decided as follows. The matter may be referred to the government of Assam in the light of the city so-and-so. Now, we lost see last paragraph. Under the circumstances, the government of Assam in the Industry and Commerce Department is required to give a decision in the case of existing unit undertaking modernization in the light of clause 12.4 of the Industrial Policy of 2008 that speaks the decision of the Industry and Commerce Department, government of Assam, is regards the interpretation of the industrial policy binding and final.
Point four.
.4 you'll also find at page 101. So this was
So matter rested at the end of the government of Assam in the Industry
Industry and Commerce Department. Now, below thereafter 2000, below a new industrial policy was announced at page. You'll also find 2014 at page 243. It starts with page number 212.
200.
12. And at page 230, my lord.
212 is what?
2014 industrial policy.
2014. Yes.
And close 4.4 at page 230.
4.4.
My
30.
My lord. Again, modernization and diversification was included. Now, you also kindly notice, my lord, that the operational guidelines were never withdrawn subsequently also. Neither the approval which was granted was withdrawn or cancelled. Now, my lord, the issue actually in fact which arises is whether the operational guidelines is binding or not. Now, my lord, I could lay my hands. I was arguing on all other issues, but I could lay my hand on, my lord, on decision of this honorable court on the same operational guidelines. I think my learned friend appeared.
Yes.
With respect to same guidelines and the submissions of the respondent at para 20 below. The learned standing council has further added that by the minutes of the meeting dated so and so, a recommendation was given to the department, which was in fact acted upon by, and subsequently there was modification of the operation guidelines. We further submit that the law being clear on the expect decision taken by the state level committee cannot be faulted with, as a guideline cannot supersede a policy. Now we'll also may kindly skip over and may come to middle para 26. This court finds force in the submission of the senior counsel for the petitioners that the first eligible certificate itself, which is dated so and so, was after the minutes of the meeting, which was on so and so. Whether a state level committee would have jurisdiction competence to question the operational guidelines framed under the policy is itself a debatable issue. In any case, the operative part of the observation is a communication to rectify the operational guidelines by issuance of necessary corrigendum. There is no manner of doubt on the part of this court that a state level committee will not have the competence to declare the operational guidelines as invalid. It would be a different matter if such guidelines were rectified by the competent authority, which in this case was not done at the relevant point of time. Now, Lord Felix. So far as submission made by Sri Kalita, the Learned Standing Council, that such change was made in the year 2014, so Learned Senior Counsel for the petitioner submit clarified that the policy of 2015 is different from the policy of 2008, and the operational guidelines pertaining to the policy of 2015 would have no connection with the subject matter in dispute. The decisions referred on behalf of the petitioners were well with regard to the binding nature of the guidelines framed by the state. So far as so-and-so referred to by so-and-so, Learned Standing Council is concerned, the facts of the case are wholly distinguishable from the facts of the present case. In the said case, the grievance was raised by the SSC, which had alleged that by issuance of subsequent guidelines, the substantive part of the policy by which the unit was claiming incentive was sought to be taken away. Under the context, the Honorable Supreme Court has held that the guidelines cannot supplement the policy. The Supreme Court had, however, made an observation as to the fact that it is furthermore a well-settled principle of law that an exemption notification must be liberally construed. In the instant case, this court has noticed that it is a case of none of the parties that the operational guidelines is the subject matter of is not the subject matter of challenge. The court is of the view that the guidelines which were framed under Chapter 12 was only to supplement the policy and make it workable. Until such guidelines were existing, it was obligation of the authorities to follow the same. This court has also noticed that while the state level committee and raised questions on the guidelines, the committee has only recommended for modification of the guidelines, and by mere recommendation, the efficacy of the guidelines cannot be held to be obliterated. In view of the above, this court is of the hesitant opinion that the decision-making process exclude the petitioner from the incentives under the component of the electric installation, other than the dollar power license held to be will have to be justified. Consequently, the impugned judgment demand notice is set aside in quash. So, my lord,
Now, after that, AITC forwarding the letter
my lord,
page,
The last minute at page 205.
205.
Right.
205. What had happened?
Well, in this case, there was no reply,
Nothing.
nothing. But in the second case,
That after 2012,
Right.
you waited.
we
Then
fi-
under what situation you have?
well, when there was no reply, no action was being taken, then we approached this honorable court in 2014. Now, my submission before Lordship is that, my lord, the operational guide as held by this honorable court, the operational guidelines have not been withdrawn, not modified. The approval which was given by the industry department had not been withdrawn nor cancelled. Secondly, assuming for the argument's sake that the operational guidelines could have been modified or the approval which was granted to the by the industry department is cancelled. Below
No,
the
why
same
operation guideline?
below the operational guidelines at page 10.
Three.
My lord. Assuming below that is modified and the approval which was given by the industry department is withdrawn or cancelled, so that same cannot have a retrospective effect on the industries which based on these guidelines and the approval given by the government.
Operation guideline includes process monitoring.
My lord.
Yes.
My lord. Now, when I informed by prior intimation I given to the industry department, AIDC, that I am undertaking modernization for claiming the benefit of the policy, my lord, at no point of time I was informed that you are not covered by for the policy modernization. In fact, the implementing agency is the, my lord, the loss you will find is the AIDC. And the Apex Court has held, my lord, that the tax department has no role in deciding the issuance of the eligibility certificate.
Just the
My lord.
now, whatever nomenclature for the benefit, 2003,
My lord.
it is expansion or diversification or modernization. The eligibility criteria is same for all three. Is it not?
My lord,
No, 2003.
I will submit, my lord, the eligibility criteria insofar as the modernization part is concerned in the operation guidelines, because modernization means what, my lord?
No, I am talking about
25% investment.
2003.
I am saying 2003, my lord, there were three conditions. Increase in the employment, local employment. Second, 25% investment in the fixed capital investment. And third, increase in the, my lord, the production by 25% based on the three. Now, in the operational guidelines, you'll also find it has been said.
2003,
I'm saying three, so far as the substantial expansion is there, three criteria is with it.
no, there is nothing like substantial expansion. It is
Yeah.
only expansion.
Expansion means, my lord, there is substantial expansion.
Now, page 81, 4.5,
My lord,
3,
51, my lord,
page 81,
81. My-
4.5, 3.
My lord,
Now there is substantial,
my lord,
right?
my lord.
And now come to page 106,
106.
6,
My lord,
first line itself. Same thing or different?
it is correct. My lord, you will also may kindly see further.
No, no, the
My
same
lord, yes.
or different?
My lord, by the capacity enhancement by way of introducing new or approved technology or process modernization or that is process modernization by way of introducing new products, services, that is product diversification. You lost me, see, my lord. Substantial expansion means and includes expansion undertaken by the existing units by way of increase in the installed capacity, so and so by way of introducing new improved technology, that is process modernization by way of introducing new products, services, and product diversification.
Hmm.
Now, thereafter, you'll also kindly further see, my lord. And the last part, my lord.
These criteria in page 81 are
lord.
also in the operation guideline.
Operation guidelines also there, but there is something you'll also see, my lord. The last also process modernization,
That is there. That is there.
my lord,
But so far, these criteria is substantial criteria.
my lord,
Page 81.
my lord.
This is in a small clause, 3,
My lord,
page 81. And this has been explained in 106.
my lord. My lord is increased capacity.
Leave aside this process modernization.
My lord,
Otherwise,
it's
this is
same.
same. So in a sense, it is same.
My lord, in essence, it is same.
And further clarified by process modernization.
Because, my lord, capacity increase is altogether different. Increase in capacity by 25%. You'll also kindly see the word.
Which word?
At the modernization, the word was there, expansion. Policy. .6, my lord.
4.6. Yeah, 4.3.
My lord. Page two criteria, my lord. And prior to the substantial expansion, you'll also may see at the top, 3. Page 181, my lord. Substantial expansion means increase in the value of fixed capital investment in plant and machinery of an existing or at least 25% as increase for the employment by 10% and at least 25% increase in the production compared to the average, the annual production of the previous 3 years prior to going into the expansion. The units should be currently at least running at the capacity of 80% or so and so.
Now, if we read 106,
My lord,
the capacity investment to increase investment in fixed assets
my lord,
by at least 25% of the gross value. That is there already.
yes, yes,
Then third paragraph,
my lord.
80% capacity minimum it should have run previous 3 years, 80% capacity. That is there already.
That is, in this case, it is not there, my lord.
Huh?
In the page 106,
It is there, third paragraph.
my lord,
Third paragraph. It is there. It should be operating at least at a minimum 80%
Well, that
capacity
is for-
during the previous 3 years.
that is for the purpose of
Huh?
substantial expansion. Because, my lord, the modernization, when we say of any industry, that modernization is altogether different concept. Is there mentioned, the managing director is also mentioned in the letter. The managing director is also mentioned in the letter on the basis of guidelines.
No, his interpretation will not take.
My lord,
His interpretation may not see about that. First,
Well,
the
that-
policy. First,
my-
the policy and the operational guidelines.
my lord, process modernization will be constituted by separately identifiable investment made by an existing and the new unit, the fixed assets in the involving the
Let
new,
us see your claim application
my lord.
that forwarded by comment with the AIDC
No, that is the report,
report. That's all.
191 my lord, inquiry.
Now, coming back to 10,
106 my lord. My lord,
whether you want to say that substantial expansion is a different concept from product process
I'm
modernization.
saying my lord, that expansion will also include the process modernization, but the result of the expansion and modernization are different. Because modernization is the new technology which is used. The investment is there. The employment is there. A latest machine which is there, new technology. Now that has been mentioned in the report also. Now my submission before Lordship is that, my lord, that we have to follow the guidelines which was approved by the government.
We're into the guidelines only 106.
So 106, whatever is mentioned, by that I am fulfilling the entire requirements, process modernization. Now, my lord, the dispute, the person who is entitled, who is competent under the policy to issue the eligibility certificate, he is saying that yes, I am entitled to the eligibility certificate. The Commission of Taxes is saying that no, I am not entitled to. That has been said by directly by the Apex Court, that the sales tax department has no role so far as the issuance of the eligibility certificate is concerned. Now, even today, these operational guidelines were never withdrawn, never modified.
I mean, to the operation guidelines itself. Let me once again read it.
My Distinguished Dharmendra Singh here.
So you want to say that substantial expansion has three alternative situations. One is capacity enhancement, second is product diversification, and the third is process modernization, right? And the conditions of eligibility prescribed for all the three are different.
Right.
Right? So the conditions required for capacity enhancement are different from the conditions required for
Modernization.
process modernization. So this substantial expansion means and includes all three. And either of the three, and your case is process modernization. So that is process modernization is not required.
Production.
Does not require increase in the install capacity, for example.
Increase in production.
Production.
Install capacity, there is no dispute.
Or increase production. That is what your submission is.
Now,
so that is your submission, and that is the view of the AIDC managing director. And contrary to that, the view of the finance commissioner of tax.
Now, no, the only question which I was asking that the commissioner of taxes is a functionary of the state. Now, what he's challenging, what he's saying, that the guidelines which were approved by the government, he's writing that which was approved by the government, were in accordance with the industrial policy of 2008. That he is saying below in the paragraph. Now, we'll also kindly take the table of 4 lines of judgment at page of compilation, page 65. 65. One compilation of judgments I've given, already given. Assistant Commissioner of Commercial Taxes. And you'll also got it.
Yes.
And you'll also kindly see page 68.
Okay, that takes care of the view of the Commissioner of Tax.
Yes, 4 lines at para
Four
5.
line we start from we.
No, it starts
Fourth line,
it
we
is
totally fail to see how an assistant commissioner
My
or
lord,
deputy
my lord.
commissioner. That is the that takes care of the view of the
Commission of Taxes.
Commissioner of Tax. What about the exemptions?
My lord,
What about the exemptions?
the exemption scheme on that, I placed a judgment.
Let us have a look.
I placed the exemption scheme is to give effect to the promises made in the industrial policy. Now, assuming for the argument's sake, the exemption scheme is not framed by the government, not framed at all.
Then we go by the direct operation guidelines as well as policy.
No. Exemption scheme was framed prior to the operation guidelines.
Right.
Now it has not
Now you said that let us assume for a moment exemption scheme is not there.
not there at all.
Then combine reading of operation guideline and policy.
Then
Then it is for your benefit.
without notification scheme also I will be entitled to. If the exemption scheme is not framed by the government, then without the scheme also I shall be entitled to the exemption on the basis of the policy and guidelines. That has been the view taken by the Supreme Court, where in one of the cases,
First, let us complete a fact.
absolutely criminal,
And we can
it has not been amended. Now your lordship cannot direct the government to amend the scheme.
no, we are not here for that.
No, the lordship.
We have to decide on the basis of
No,
material and
but
record.
I submit, Lord, I cannot make a prayer before lordship that a direction should be issued to amend the scheme. I cannot make a prayer at all. My prayer is that that exemption scheme is only to give effect to the promises made in the industrial policy. Now, if I am entitled to the exemption, whether the state government by way of amending the scheme or by way of any way, they will grant the exemption, it is up to the state government. Because in a similar circumstances where the notification was not issued, the apex court said that we cannot direct the government to frame the scheme or issue notification, but on the basis of the promise estoppel, we direct that he will be entitled to the exemption on the basis of the industrial policy.
So I want to just have a look at the.
Absolutely, my lord. I'm sorry, my lord. I should have taken your lordship to the scheme which I am annexed, my lord.
Then it will be better for me to understand.
No, my lord, I'm really sorry, my lord. I should have taken the scheme to my aid. Right? This is scheme no. 9.
Yeah, in 2009 scheme.
9 scheme. No, I'm just, your lordship, give me 1 minute. 196. Huh? No, 196 page. Page 196. My lord.
What is your category? Category C.
My lord,
Your category will be category C.
my lord, I'm just
As per this scheme,
in this scheme, my lord.
as per say, for example, this scheme, particular scheme of the 2009 scheme.
Say, my lord, B it will
B or C?
B,
It will be,
B.
my lord.
And B. B. What is category? Then rule 4.
Rule 4, my lord. My lord. Procedure for grant of eligibility certificate for ABC.
An eligibility falling under category A, B.
My lord,
Suppose your category is B.
my lord.
Has to make an application in format Annexer 2.
My lord,
Annexer 2. Your application was in Annexer 2,
my lord.
right? Perhaps.
Well, it was an eligibility certificate.
Substantial expense 124.
My lord,
Okay, 128. Then what is the authority? Who is the authority?
industry
Construction scheme for issuance of eligibility certificate to specified authority, namely so and so state level committee or special.
Assam Industrial Development Corporation.
Why?
Well, I-
AID, there are three committees are there. One
oh.
is state level committee and one is district level committee, one is state level committee, and one is AIDC committee.
What is the criteria?
medium and large.
It's a large, middle and large industry.
Which is large?
It's a large, middle and large industry.
You'll also find
So
at
it is
page
a-
200. 14C, my lord.
200.
My lord.
Which one?
14C.
200. C.
My lord, page number 200. 4C, my lord.
4C.
My lord.
Okay. And what was your certificate granted?
No, certificate has not been granted to me.
But forwarded.
Provided, my lord, that your application,
AIDC.
my lord, that 190. And my application is at page, my lord.
No. That MD forwarded.
Well, MD forwarded.
MD, which is comment.
My lord, page 190.
That AIDC MD grants eligibility certificate.
Right.
Then what is the next stage?
Then, my lord, the certificate of entitlement is there.
Okay.
Which is under the scheme.
Huh?
Which is under the scheme.
What is his discretion to reject the application
My
or
lord,
withhold? Page 202.
page 202.
We'll come to your submission later on.
My lord, my lord,
I want to understand.
my lord.
Under what authority he has issued that letter?
202, my lord.
Roman 3,
Roman
small Roman.
202, my lord. Small Roman 3, my lord. The commissioner, the assistant commissioner of taxes, the superintendent taxes, as the case may be, shall withhold the issuance of certificate of entitlement or refuse to issue the application, and the documents accompanying there are not found to be in order, and the condition laid down for the purpose are not fulfilled if such information furnished is not correct. But I apply and I documents and information which I furnished, they are not correct.
No. I'm just trying to are not found to be in order,
Order,
and the conditions laid down for the purpose are not fulfilled. And or
my lord,
if any information furnished is not correct.
my lord.
He's not saying that any information furnished is not correct. But first part, are documents accompanying therewith are not found to be in order.
In order.
That is not his view.
Hello?
That is not his view in the letter.
No.
And the conditions, I think this is two. If that, because there are two ifs.
My lord,
Two ifs. One, if the application and documents
are not in order.
accompanying therewith are not found to be in order and the conditions laid down for the purpose are not fulfilled.
My lord,
And second, if the information furnished is not correct. Second is absolutely out of the way. Now, first is accompanying are not found to be in order.
I don't enclose the eligible certificate.
Right. That is what I am trying to find out. What kind of
My lord, that assuming
jurisdiction he exercises?
my lord, he has to only verify whether the proper documents and papers have been submitted or not.
Maybe in view of this jurisdiction, your page 68 may be correct.
Yes,
Page 68 of that paragraph.
my lord.
I am
Look at-
trying to
No.
test it.
I'm grateful to your lordship, my lord, when your lordship is asking
So
queries.
his jurisdiction is limited to this.
Only verification.
He cannot, whether he commissioner can sit upon the scheme. He
absolutely.
cannot, he has no authority to sit upon the scheme perhaps.
Absolutely. On the deciding of the eligibility, he cannot.
He has to leave it to the authority, issue of certificate of entitlement.
My lord,
Issuing authority is for that procedure for grant of eligibility certificate.
my lord, that is a
Those
different-
are authorities,
My-
AIDC, state level
my-
committee,
my-
and so and so.
my-
Then matter has been sent to the commissioner of tax. Then he has to examine, and I think his jurisdiction is, if it is
My lord, what
found
the-
satisfied, then he will grant.
but the reason is
When he is not satisfied,
when
these
it-
are the reasons.
my lord, the reason is that for certificate of entitlement, I may also inform your lordship. Assuming, my lord, I am entitled to 5 crores of exemption. Now, eligible certificate is issued for 5 crores exemption. Now, entitlement certificate every year I have to renew it, because it may be that in the first year I complete 3 crores exemption, so it will be only 2 crores available. Assuming I finish the 2 crores in the second year itself, then the certificate of entitlement will not be issued to me for further.
Then one more query.
My lord,
What about that government letter on the basis of which he is making these comments?
government letter, my lord,
He made reference to some government letter, right?
that is approval. But that letter, my lord, that he says that your lordship will see,
Where is that?
that is annexed in the affidavit.
Ah, 6/11/2008.
My lord,
Let us see that order.
affidavit to this, That is has been filed on page 251, I think.
Affidavit by Finance,
But this is by sworn in by
Finance Commissioner of Tax.
Anumat Chaudhary, my lord. That is the Joint Commissioner of Taxes.
Already much.
In fact, the first page which you have annexed is absolutely not clear, so I have got it typed for your lord.
No, it's possible.
When then, my lord,
In the
lordship may just
I am directed Finance Department. Now, when the industrial policy was announced,
2008,
date.
110.
These are all prior. Huh? Industrial policy.
No,
Now come to the comment first, then in the letter. I am directed to furnish below the comments of the finance department on the draft industrial policy. Draft.
It was the view taken, lordship, basically.
No, then I request you to examine the comments of the finance department as furnished below and make necessary modification in the draft accordingly. The revised draft as modified may please be submitted to the finance department once again in relevant file for further examination. Right? When it was announced, industrial policy,
Later on, lordship, it was
tell me that date 25/1, 12/5,
2009.
2009. Then thereafter much water has flown.
Lordship, this
Much
was
water has flown.
Yes.
This is much prior to draft. This is at the time of draft industrial
drafting
policy.
of the policy, lord,
Draft of. Ultimately, views of the finance department was taken.
taken.
Then thereafter, again, they asked for resending or modification.
No.
Please read this letter.
This letter, yes, lordship.
Subject.
Yes.
Written to the industry department.
Correct, lordship.
Subject. Views on draft
These are
industrial
draft
policy of Assam.
2008. Correct.
Now read.
I am directed to furnish below the comments of finance department on the draft industrial policy 2008 and request you to examine the comments of finance department as furnished below and make necessary modification in the draft accordingly. The revised draft as modified may please be submitted to the finance department once again. Once
For
again,
further examination.
yes, if at all required, yes, lordship. Then lordship, the definition for lordship may come.
We don't. Why we should go?
No, lordship. Yes,
These comments were asked for.
correct.
Finance department had provided the comment.
Comments.
Then they asked for resending it. Right. This deliberation was
Correct. Going on.
prior to 12/5/2009.
Correct.
Ultimately, everything has been, all these deliberations, these are intra-departmental,
Department.
and everything has been culminated into the
Draft. Sorry,
No,
policy.
policy
Correct.
announced on 12/5/2009.
Correct.
Now, he cannot refer, this man cannot refer to 6/11/2008.
No, what?
By no means.
Yes.
He can refer to scheme. This here,
No, I appreciate.
6/11/2008 was a letter prior to notification of the industrial policy.
Correct.
At that time, the process of deliberation was going on.
Correct.
Finance department forwarded its comment.
Correct.
Industry department has taken note of.
Absolutely.
Ultimately, it culminated into a industrial policy, 2008
Policy.
on 12/5/2009.
Absolutely. There is
So,
no dispute.
he has no occasion, this man has no occasion to refer to 6/11/2008. He can only refer to the scheme framed in 2009 based on industrial policy 2000.
Correct.
He cannot, and by encroaching in government letter, he cannot sit upon the
No, Lordship, what has
That's,
happened?
no, I want to be clear on the same.
Lordship, I'll just clarify, Lordship, one thing. Lordship, while Lordship was hearing this matter earlier, so there was a question came.
Right.
Why this policy changed suddenly? Then we have explained that there were some deliberations happened.
Right.
And
That is what I am
yes,
trying.
correct. So after this deliberation,
So, no, he is commissioner of this letter because he has created this. He is out of this entire letter. I think 6/11/2008 is of no relevance. That is what I am saying.
because it's already been like concretized and it has already been done a policy.
Interdepartmental communication is of no substance.
So it's because it
That's
has already become a
because already it has culminated into a
policy.
industrial policy and subsequently a tax exemption scheme in 2009.
Lordship,
That is what I am to find out.
absolutely right. I don't have any dispute. Absolutely.
Now it will be the industrial policy
Vis-a-vis
exemption
operational
scheme
guidelines.
2009 and approval of the operation.
Absolutely.
That's all.
That's
And plus vis-a-vis the facts of the present.
correct. Sir. This was filed only because Lordship, there was some query. came up.
Because he is referring unnecessarily.
May I read the next line immediately after melody 6/11/2008, page 195. He has just narrated the fact. He has not relied upon this, but he has narrated.
How it has happened?
As regards the views in respect of Assam Rupee, it may be stated that at the time of drafting of the Industrial Policy 2008, the process of diversification and modernization was also proposed for exemption criteria. In this respect, we furnished our views to the government. Accordingly, the government sent views to the Industries Department by letter dated 6/11/2008. Copy enclosed. Thereafter, he says, thereafter, in the Industrial Policy of 2008, the new definition of substantial expansion was included, wherein there is no mention of diversification or modernification. So he narrated the fact. He has not stated that.
No. When the
narrated the
operation
how-
guideline was approved,
Well, operation guidelines was approved on date 2010.
so he has omitted to discuss operational guidelines.
My lord.
That is speaking one thing,
That's lordship on the-
omitting one thing, that is not proper exercise of power.
My lord.
Operational guideline was not under his purview, so he hasn't mentioned
No.
about this.
That is not the correct.
No, your lordship,
Sitting over a matter, over a policy of a government, he should not do that. When it was approved,
Well,
operational guideline,
25/1/2010.
it is not his case that he is not known. 2012 he is writing.
The Lordship has to keep in mind one thing, that this tax department, this commissioner is the part of the AIDC committee. So he has every right to speak about the policy. He's part of the committee, Lord.
I will show you are a part of the committee, but you have no role. You cannot take an upper hand. That is very correct. And you yourself argued the matter before the single judge.
But I point out what has happened before that.
No, because
That
he is
is-
making comment. He is just a official of the contract.
25.
He is not a commissioner secretary. That's we are on to this last bit.
Page 1.
Therefore, the
70.
definition of substantial extension includes the operation guideline, which your department has approved. Right?
Right.
It is government, not operation guideline is approved by government, I think.
Yes.
Not by director of industry.
No,
Perhaps.
we will see the language, Lord.
Yes, yes.
See,
171.
195.
171 approval.
No, 190.
My lord. I'm sorry, my lord. Your lordship is-
We are testing his.
My lord.
We are deciding a case on. Therefore, the definition. He is making his final comment.
So Lordship, that
Operation guideline. No. He is a functionary. Before making
he is a
comment.
member of the committee which has been specifically formed. under the policy.
No, he is not writing as a member of the
He-
he is part of that scheme. That scheme. He's an authority. Other is authority.
He's a part of the committee.
He's member of a Mr. Kalcha.
Perceive he's
Speaking as a member of a committee is one thing. As a authority under the 2009 scheme is one thing.
Yes.
He is speaking as an authority under 2009 scheme. Okay. It is permitted.
Correct.
He is not speaking as a member. He is aware of.
Even if he wants
So,
to
like-
speak in the member, my lord,
No, no.
170
No. He has observed that
as Commission of Taxes.
as
And-
Commissioner of Taxes,
And, my
the
lord, even if he wants
definition
to-
of substantial expansion included in the operational guidelines, which was approved on 25 of October. This is your document.
my document.
Industry. Your document, he is doubting, is not in conformity with the principle laid down in the industrial policy 2008. So your operational guideline approved by Industry and Commerce Department on 25/1/2010.
So he's pointing out a flaw there.
Floor,
Point the pointing out the flaw and sitting on judgments are two different things.
Two differences. Absolutely. Now, Lordship, that 171 document, Lordship, that I'll read out.
No,
170.
we're not completing this. We're just
Yes, Lord,
in between.
my senior can.
my lord, if my learned friend can say it was not
Yes.
approved, if it was not approved, then I have no case at all. If it
No, I
was
have
not
not said-
approved, then there is no case at all, because my entire case is that it was approved. Your lordship may kindly seek the compilation, my lord, for time.
I have seen the fact,
My lord, compilation, your lordship may con-
your side of the fact.
I'm obliged, my lord.
I'll say your side of the fact.
Your lordship has better seen the fact than, in fact, I have seen. The compilation, my lord, at page 58. Your lordship may kindly see
The
Lloyd Electrical judgment of the Supreme Court, my lord, 2016, 1 SEC 560,
page
page 58,
50.
a relevant part at page 62, my lord. Paragraph 14.
Yes.
Paragraph 14, my lord. The state government cannot speak in two voices. Once the cabinet takes a policy decision to extend its so-and-so policy, the matter of the CST concession to the eligible industry beyond so-and-so and be so-and-so accordingly having been issued by the department of the concern, that is Department of Industries. Thereafter, the Excise and Taxation Department cannot take a different view. What is given by one hand cannot be taken away by another hand. The government shall speak only in one voice. It has only one policy. The department are to implement the government's policy and their own policy and not their own policy. Once the Council of Ministers has taken a decision to extend the so-and-so policy and extend the tax benefits, tax concession beyond so-and-so, merely because the excise and the taxation department took some time to issue the notification, it cannot be held that the eligible units are not entitled to the concession till the department issues the notification. You will also thereafter see, my lord. Paragraph 15. It has to be noted that the finance department of the state government has concurred with the proposal of the Department of Industry, Commerce, the tax concession beyond so-and-so, and the Council of Ministers, and according to a decision also, no doubt, the statutory notification issued by the Excise and Taxation Department under section so-and-so has stated that the eligible units will be entitled to the concession and with immediate effect, merely because such an expression has been used, it cannot be held that the state government can levy the tax against the own policy. The state government is bound by the policy decision taken by the Cabinet of Commissioners and only notified in the department concerned, that is Department of Industries.
It is in regard to any industrial policy
My lord,
decision.
industrial policy. Now, your lordship may kindly see at page 1, my lord. And paragraph 9, I will take your lordship.
Around 9.
My lord. And paragraph 22, my lord, page 9.
Page 9.
Page 9. Page 8, my lord. I'm sorry, my lord. I'm sorry. Furthermore, under the incentive scheme mission, there was only one method of verifying the eligibility of the various incentives granted, including sales tax exemption. The procedure was the matter was to be scrutinized and recommended by the state level committee and the district level committee, and the certification by the Department of Industries and Commerce by issuing an eligibility certificate. There was no other method prescribed under the scheme for determining an industrial unit's eligibility in the benefit granted. The Director of Industry and Commerce, having exercised his mind and having granted the final eligibility certificate, when was valid at all times, the Commercial Tax Department could not go beyond the same. More so when the Commissioner of Sales Tax has accepted the eligibility certificate issued to the applicant and has separately modified the applicant's eligibility under so and so. In such circumstances, the city certainly could not assume that the exemption was wrongly granted, nor did he have the jurisdiction under Section 20 of the State Act to go behind the eligibility certificate and embark upon a fresh inquiry with regard to the applicant's eligibility for the grant of the benefits. The counter affidavit filed by the respondent sales tax department is telling it is said that the sales tax department decided to cancel the eligibility certificate of the sales tax incentives. As we have said, eligibility certificate was issued by the Department of Industry and Commerce and could not be cancelled by the sales tax department. Thereafter, Your Lordship, there is another reason why the action of the city cannot be upheld.
Who is DCCT?
The Deputy Commissioner of Commercial Tax. There is another reason why the action of the city cannot be upheld. The primary facts relating to the process undertaken by the appellant in its unit were known to the Department of Industry and Commerce and the city. The only question was whether the proper conclusion to be drawn from these facts. The Department of Industry and Commerce, which was responsible for issuance of the so-and-so government order, accepted the appellants as an eligible industry for the benefits. Apart from the fact that it can be assumed that the Department of Industry is in the best position to constitute its own order, we can also assume that in framing the scheme and granting the eligibility to the appellants in the departments of the state concerned involved in the process had been consulted. The state which is represented by the department can only speak with the one voice, having regard to the language of so-and-so order. It was the voice expressed by the Department of Industry which must be taken to be the voice. So, my simple submission, below, the Commission of Taxes has nothing. As my learned friend said, he was a member. He could speak in the meeting as a member. Outside the meeting, he had no role.
Individual member he had vote, but the team he may have vote.
He speak in the meeting, my lord, when he decided he is a member. He may discuss, he may express his views, everything. After all, the decision of the will be of the committee. The decision is never of the individual member, my lord. Now, Lordsman, kindly see, my lord. One more judgment I will place before Lordsman, my lord. that is page 17. That is decision of the Allahabad High Court.
Now, in such situation, in view of absence of any eligibility certificate, issuance of eligibility certificate, or eligibility no entitlement certificate, AIDC has issued eligibility.
No. He referred the matter to the industry department.
How can he? How can he?
He has said that yeah, he's eligible.
Who has,
No, no,
Sir,
no,
it has been referred by the AIDC managing director.
I am saying that.
no, just again we have to see the scheme. Again, let us see the scheme,
Policy, my lord.
not policy. Policy.
Because
What is the
scheme
procedure? What is the procedure?
procedure is that, my lord, the industry AIDC will decide.
Yes, where is that? Process has been halted at an intermediate stage. So
My lord.
at what stage it has?
Well, after receipt of the letter from the Commission of Taxes,
Right, that later.
he referred the matter to.
Now, what is the procedure?
Procedure is that, my lord, after his eligibility, he decides.
Now,
He has-
where is the later? Is it later
Lordship,
perhaps?
Chapter 12, page 98. Lordship will
Page
find the
98.
implementation and monitoring.
Yes,
Page 98, Lordship. will have.
Okay.
So there, Lordship, how this, different committees will function, all these details. Are.
AIDC committee.
Yeah,
It falls
AIDC
under AIDC committee.
Yeah, C, Lordship will find AIDC committee. These are the members.
Is there
These are the
commissioner of
members.
tax?
Yes, he is one of the members.
Now, what is the procedure? If they have submitted the application form to the AIDC, right?
Sure.
And I think AIDC managing director wrote the letter.
So he is the authority, Lordship. I'll just show. So Lordship may come to
We are
page
including an
99. Page
application
99.
received from for grant of where is the occasion for asking for comment in the procedure?
Operational guidelines, Lordship will find.
Yeah, but
That is there in operational guideline, chapter 2.
Two.
Procedure for issuance of eligibility.
that page.
Page 108.
So you accept the operation guidelines?
So we are not denying the whole operational guidelines. Lordship.
How you can deny?
We are not
How
denying the
you
whole.
can deny that has been approved by industry
No,
department?
let us read. Let us read.
Lordship, procedures for issuance of eligibility certificate.
Right.
Applications for grant of EC to be submitted to GM.
MT.
So this is for small, micro, small, and to MD AIDC for medium and large
Right.
scale units. Then new units shall apply for EC in Form 1A. Similarly, existing units undertaking substantial expansion shall apply in Form 1B. So Lordship may kindly note this thing, existing units undertaking substantial expansion. There is no mention of modernization or diversification there.
No, AIDC represented. AIDC party.
Expansion shall apply in Form 1B and SIC units relief undertakings in Form 1C. Then Lordship 3, General Manager DICC shall forward the applications of small scale units along with inquiry reports as per prescribed form Performa G and other specified documents to Commissioner Industries and Commerce, Assam for its consideration and ultimate approval of SLC. Commissioner of Industries and Commerce, Assam, and General Manager DICC shall.
Those are not relevant.
These are not relevant. Similarly, in case of medium and large scale units, Managing Director AIDC shall issue EC after obtaining approval from AIDC committee.
So one first thing, MD has to issue EC
Correct.
only after approval of the committee.
Committee.
Right. Whether this approval was available.
Oh, it was,
Yeah, my lord, in the SLC
It was
meeting, he had mentioned,
Let us proceed part.
while considering any unit for grant of eligibility certificate, AIDC committee shall ensure that one, proper inquiry have been made by implementing agency concerning engaging their field officer. And two, the EC applications have been recommended for granting incentive.
Who recommend?
Committee recommendation.
Who recommend? Field officer is definitely from the AIDC or
This is
Roman 2. EC applications have been recommended for granting incentive.
yes,
What is that?
field officer. Yes,
So there are three stages.
correct.
Firstly, that implementing agency, AIDC is implementing agency, no doubt. AIDC is the implementing agency for big and
Correct. Medium and large.
large.
Correct.
So it is the implementing agency. Proper inquiry have been made by the implementing agency concerned engaging their field officer.
Field officer.
So AIDC will engage field officer,
Field officer.
right? That
Correct.
is one condition.
Correct.
Second condition, EC applications have been recommended for granting incentive.
Correct.
That is the second condition.
Second, EC applications have been recommended for granting incentive. Whatever.
That is the second condition.
Second.
Who will that field officer?
That AIDC company.
AIDC. The third is after obtaining approval from the AIDC.
Correct.
Right?
Right.
Whether approval has been granted.
Page 109. That is the third stage involve two specific applications.
Where is the AIDC forward? One. One.
What is the
And 193.
Yes,
That is recommended.
193 is the
Recommended by the committee. Here is the
This is the report. This is the report. And
No, no.
this is an initial
no.
recommendation, kind of initial recommendation.
page 193. I think they have went for physical verification
And recommended.
and that is inquiry by field officer
Yes.
and recommendation.
Yes, so inquiry officer will do some field work there. Field visits will be done. Then they will say that this is the amount they are recommending. But
Right.
these
So,
are the field officer.
so 108.
Got
Apart from this Roman 1 and 2, proper inquiry have been made by the implementing agency concerned engaged their field officer.
Field officer.
And they have been recommended for granting consent. Now, question is now has been figured out that AIC committee cases process, they have processed and obtained approval of their step. That is the only, that is the state.
Where is the state?
That is the state. So, according to this particular chapter 2, AIDC prior to issuance of eligibility certificate
Takes the opinion from
has to take the opinion from the
Sales
state
tax
department. So that is when this lease is at this lease is regarding that state.
Yes. That's
We have to be sure, otherwise
no, that is the
At
state.
that point, my lord, the matter of
call it. That is what the issue
Actually,
is.
correct.
Because that determines what kind of observation is to be made.
Yes. Actually,
So it is not the stage of eligibility certificate, issuance of eligibility certificate prior to the
prior to
It's-
issuance of
it's
eligibility
state-
certificate,
just prior to the
Correct.
issuance of eligibility. Then that this authority has made his comment
convention,
and has stopped the process.
they got stuck in there.
Got stuck. That is the case.
Uh,
That is the case perhaps.
The matter was placed in the state level committee.
Huh?
The matter was placed in the state level committee.
State level committee.
My lord, you will also see page 1205,
205.
my lord.
Because it is so bulky.
My lord,
So fish out the relevant things.
you will also kindly see, my lord,
205.
and relevant part at 206.
Okay.
Last two paragraph, my lord.
Who is writing this letter?
And managing director AIDC.
Petition. Okay, after writing of this letter
My lord,
by
after
the
the-
commissioner.
my lord. That letter was placed in the meeting of this SLC. It was deliberated.
1 minute. Let me. Okay. Wait. Commission. Yes, it is the industries department under clause 12.4.
That's the decision of the industry department will be final. Now, the AIDC is saying that by virtue of 12.4, it was approved. The guidelines were approved.
Then it is guidelines.
So once it is approved,
Now, so 12.4 is 101.
my lord, on interpretation of
So what interpretation you have given? What interpretation?
The Lordship, then they have approached the this honorable court. Then during the pendency of this petition, another petition was filed. Then in the another petition, Lordship, that AIDC has rejected their already rejected their eligibility.
on not prior to that, you saw it, the commissioner's letter, the finance department letter.
I mean, when the matter was pending, the AIDC has taken a decision to reject it.
Which one?
This
Which one?
eligibility.
In another case, not in
In
this
another case, but like it is there in the record. In another other petition, Lordship will find.
Yeah, okay.
It's for what? 2070, same petitioner,
Another unit, my lord, of the same person,
another unit.
my lord.
Not right. The same issue, same.
So and there is no finality in this case.
Lord, in this case also, if you want to argue, you can argue.
Okay. What is the other?
In the another case also, my lord, the same view was there. Thereafter, my lord, the letter was written at your lordship find page 189.
189.
I understand is saying, my lord, that the AIDC rejected. Why it was rejected, that your lordship will see page 189,
189.
my lord, in the second case.
Yes, sir.
One 189. Security.
We have not considered the operation guidelines and its approval.
What is the meaning of this letter?
My lord,
189.
189, my letter has been written to the managing director. In reply. Now, your lordship see the last paragraph. That is material. First, it is about the High Court's case. We are not concerned. Ultra vires to provisions of the value tax. The unit is not eligible to tax incentives since it undertook modernization, which is not an eligible activity for the purpose of exemption under the industrial policy of 2008. Now, the authority has not taken into consideration that the guidelines were issued and it was approved.
No. This secretary is writing to the managing director.
on the basis of
No,
his letter.
Some letter.
Yes,
He's
yes.
referring to some letter. Where is his
Page
decision?
188,
Where is his decision?
well, page 188, the letter may kindly be seen. Commission of Tax, I'm prior to that minute, I'm just. It is 186, my lord.
Mr. Kolda, this is the decision.
Okay.
The decision.
This is the
189.
decision in the other, they have filed two applications.
No. In the other one.
Yes.
This is your interpretation of the
The
industry department.
2000, I mean, that 190 is the ultimate rejection of the eligibility.
190.
190. Pagination may be wrong, but it was 191.
190.
190.
No, my lord. It is 190, 191.
191. Here the pagination.
No. Whose letter hai? Annexer.
Yeah, this is Lordship Annexer 15. Roman
Annexer.
115, 16 2007.
Yes, annex the letter
No,
received
I
from
want to just understand that in the other one, AIDC has fought for views because of this development, finance department view, commissioner taxes, exemption scheme, and state level committee. And he said because of 12.4, I think.
Yes, Lord. That Industries Department should be the final authority, and like Industries
12.4,
Department should
that because of this, they making various things.
Good.
Authority in the industry part
that's MDC.
in view of 12.4. Now, in the second application, I think eligibility certificate was applied for perhaps.
Then they come to a conclusion that it is rejected. Second.
This is the just I want to ask this page 189,
my lord.
annexer 13.
Yes, Lord.
Is this the final opinion under 12.4?
This is not 12.4. My lord,
This
12.4 is the opinion. You know, see, it is addressed from the Commission of Taxes, Department of Finance Department.
Annexer
Annexure 13, I'm saying, you know.
Page that one.
If we all, it will become confusing. Let me place it. My lord, what happened, my lord, I will tell you also, my lord. There was a case filed before the Guwahati High Court, this honorable court, challenging the validity of Rule 57A.
That is different.
That is different.
Yes.
No, case may be different. Let me place it. I will not place anything irrelevant. Whatever is there, let me place it.
in the
I'm
second
agreeing
case,
to your-
Mr. Kolita,
What's it?
you have said that industry department has rejected
Yes.
the case of the petition. In
In
the
the-
second report.
In the second one, Lord, AIDC has rejected. So AIDC is the committee, ultimate committee.
Well, IDC has
The
forwarded.
first one, AIDC got confused,
AIDC got confused. They wrote.
or they thought that it is better that industry department
To take a
arrive at
decision.
a
To take a decision. So Industries Department finally did not take any decision for some time. Then they have approached the court in the meantime. In the meantime, they have come to this honorable court. So it remained like that.
Ultimately, it was at the stage of phase 206 in the first case, right?
First case, yes.
Right? Everybody agree?
Correct. It was in the
206.
it was before
Then
Traffic
requisition was filed. In the what is the
in the second case.
main event in the
Second case,
in the second case? What are the main events?
the same things, Lordship.
Then
It's
who had now taken the decision.
Ultimately, ADC has taken a decision. ADC committee has taken a decision. ADC committee has taken a
Okay,
decision,
how-
and that
How-
was communicated to them.
How now better wisdom has prevailed?
That I can't be answering because I won't be able to answer it. How wisdom has come to them.
I will
Wisdom can come to any,
No, I will answer,
to
Milord.
anybody at any time, Your Lordship.
Please. Your
While
Lordship, see-
the case was pending, there was a lot of deliberations going on, and wisdom may have come to them that they can decide it, and they've decided it.
They've decided, Your Lordship, see
Correct.
page 191,
Very good.
page 191.
Very
Speaking against himself, what he's saying.
And this is the opinion of the industry department.
The AIDC.
189.
89 Industry Department,
189 is your industry department.
Industry
view.
department has it.
Very good.
191, Your Lordship,
We'll
kindly see.
continue further. Not possible today.
He has simply forwarded the letter of the Commissioner of Taxes and the Industry Department letter,
I have seen.
and my learned
I have
friend
seen
says that he have applied.
12.4 in the context of 12.4, page 189 in the second. We'll continue. We
Your
are
Lordship has to see.
running out of time today.
Your Lordship has to see, my lord, that what was the clarification sought by the AIDC? The clarification sought was about the Rule 57A. Rule
No, I have
57A.
not gone through that,
My-
so I will not make any comment.
No,
I have just gone through the events which occurred in the first repetition.
but this
Till
is-
now, I have just
Yes, Lordship is very clear about the facts. Second case.
Second also, Your Lordship is very clear.
A little bit of
no, Mr. We'll keep it on the next Monday or Tuesday at 3 o'clock because this court has already fixed
Lord.
6 cases for delivering order on the
But I will only request,
plus 1 High Court matter day to day.
but I will,
So I'll not
my lord, this,
now I'll not forget next.
the gap may be little less, my lord, so that the matter can be taken up. Otherwise, my lord,
No,
because Your
no,
Lordship
Mr. Saraf, there is one difficult. From Monday onwards, I'll be sitting in division.
well, I can understand, my lord, the difficulties, my lord.
So,
I can
and I
only-
have already fixed 6 matters
I am
for
only, my lord,
Thursday.
I only
So
for your,
we'll fix it on a fixed date next Tuesday. And because there will be division bench, Mr. Gogoi. 3 o'clock.
3 o'clock, my lord.
3 o'clock.
My lord,
the Lordship.
Then I'll finish my business in the division bench.
Lord, if Your Lordship,
Then I can sit single.
if Your Lordship give me liberty, may I prepare written submission if Your Lordship so grants
But
permission?
it should be short.
Your Lord, short,
Lordship,
Okay.
21 there will be little bit.
Okay. Okay.
21 Lordship is a series matter that bench will sit at 2 o'clock in the afternoon. It's a series matter. Especially the bench is considered on 21st.
25.
So 23rd Lordship, if it is 23rd Lordship.
Okay, I don't know. We can do it. 22nd?
22nd.
22nd? Because I have to finish the
in the second half, my lord.
second lap only because
My lord, because one matter is fixed in Meghalaya, so I have to do virtual.
otherwise we'll accommodate
My lord,
22nd.
3 o'clock.
2
We'll
o'clock, my lord,
record
better.
that.
My lord, if it is,
We'll record that 3 o'clock.
if it is 2 o'clock better, there's no that we can finish.
No, Mr. Saraf, there are division bench is to be given precedence.
My lord, I will do one thing, my lord. I will do facts, Your Lordship. Judgments also maximum I placed. I prepare, my lord,
No, because many months have gone by, so I have lost touch
I
with the brief.
prepare a judgments also, whatever are there. So that only for
Dr. Saraf. Ganesh. By Peterboard. I got confused with NN Bora, and both are almost similar. NN for the petitioners in 2797-2014. I have only heard you on this. Mr. Gugoi Equilta or Mr. as the PDO for AIDC at present. This the case. The case to be listed again on 22nd 25 2024. case will be taken up at TP.
Lord, your lordship mentioned both, otherwise one matter will go away.
Two matters, sir.
There are two matters.
No, no, orders will be same.
Others.
Orders, both one order.
And other tax matters are there. I think there is no use. First, let us finish up.
Let us finish this one.
I am grateful to your lordship.
Other matters, I don't think.
It will again will come in the new usual course. Once
No,
those-
other councils are, nobody is available.
we are available in two matters.
Okay, let it be.
To come in the usual course.